Go right ahead, Representative.
Thank you, Mr. Chairman. Chairman Hunter, Vice Chair Hernandez, members, thank you for allowing me to lay out House Bill 4. We have a crisis at our southern border. An unprecedented number of people, including a growing number of terrorists, documented terrorists, drugs and weapons continue to illegally cross our southern border into Texas. Governor Abbott, Texas Department of Public Safety, Texas National Guard continue to work together to secure the border and to prevent, detect, and interdict transnational criminal behavior between ports of entry. Since the launch of Operation Lone Star, the multi-agency effort has led to approximately 500,000 illegal immigrant apprehensions, approximately 35,000 criminal arrests, and more than 31,000 felony charges reported. In the fight against fentanyl alone, Texas law enforcement has seized over 429 million lethal doses of fentanyl. Texans know that the Biden administration has failed and refuses to enforce federal immigration laws and to secure our border. Mexican drug cartels continue to traffic fentanyl and other illegal drugs into our state and our country, and continue to traffic men, women, and children to be held into servitude to them. Our cries for help and enforcement of our existing federal immigration laws have been ignored by President Biden. We have had enough. House Bill 4 addresses this problem head on. House Bill 4 is a landmark bill that allows Texans to protect Texas and to send illegal immigrants back and to prosecute and incarcerate those that refuse to leave. Under House Bill 4, for the first time ever, Texas will subject people to detention and arrest for illegal entry into our state from a foreign nation. All licensed law enforcement officials in Texas will be authorized to arrest or remove any person who illegally enters the state, with penalties of up to 20 years in prison for refusing to comply with an order to return. To crack down on repeated attempts to enter Texas illegally, illegal re-entry will be penalized for up to 20 years in prison. Now, let me take a moment to explain the bill. House Bill 4 specific provisions are summarized as follows. First, Chapter 51 is added to the Texas Penal Code. Section 51.01 defines alien and port of entry, as those terms are defined under existing federal law. Then Section 51.02 provides for the offense of illegal entry from foreign nations, stating that a person who is an alien commits an offense if the person enters or attempts to enter this state from a foreign nation at any location other than a lawful port of entry. A first offense is a Class B misdemeanor. This language is nothing new. It tracks existing federal law, 8 U.S.C. 1325. Additionally, so as not to conflict with existing federal law, this section provides an affirmative defense to prosecution if the federal government has granted the defendant lawful presence in the United States or asylum, the defendant's conduct does not constitute a violation of 8 U.S.C. 1325, or the defendant was approved for benefits under DACA, the Deferred Action for Childhood Arrivals Program. However, under subsection E of this provision, a peace officer may, in lieu of arrest, remove a person detained for a violation of this section by collecting their identifying information, transporting the person to a port of entry, and ordering the person to return to the foreign nation from which the person entered or attempted to enter. This process is similar to existing federal law providing for removal under 8 U.S.C. 1225. Then under Section 51.04, a refusal to comply with an order to return to the foreign nation from which they entered or attempted to enter is a second-degree felony punishable by 2 to 20 years. Now, further, Section 51.03 provides for the offense of illegal re-entry by stating that a person who is an alien commits an offense if the person enters, attempts to enter, or at any time found in this state after, 1, being denied admission to or excluded, deported, or removed from the United States, or 2, having departed the United States while an order of exclusion, deportation, or removal is outstanding. That offense is a Class A misdemeanor, but provides for an increased penalty based on prior convictions or removals. Again, this language is nothing new. It tracks existing federal law, 8 U.S.C. 1326. Section 2 of the bill amends the Civil Practice and Remedies Code by adding Chapter 117 dealing with indemnification relative to enforcement of the aforementioned penal code provisions. Section 117.002 provides that unless a court or jury determines that a local government official, employee, or contractor acted in bad faith, with conscious indifference, or with recklessness, the local government shall indemnify an official, employee, or contractor of the local government for damages, including attorney's fees, arising from a cause of action resulting from actions taken to enforce Chapter 51 of the Penal Code. This indemnification is not subject to the payment limits described in 102.003 of the Texas Civil Practice and Remedies Code. Then Section 117.003 provides the same protections for state officials, providing that unless a court or jury determines that the state official, employee, or contractor acted in bad faith with conscious indifference or with recklessness, the state shall indemnify the elected or appointed state official or state employee or contractor for damages arising from a cause of action resulting from actions taken to enforce Chapter 51 of the Texas Penal Code. Further, the state official, employee, or contractor entitled to indemnification is entitled to representation by the Attorney General, subject to the provisions of Chapter 104 of the Civil Practice and Remedies Code. Lastly, Section 117.04 provides that for a civil action brought under 117.02 or 117.003, an appeal must be taken directly to the Supreme Court of Texas. Now, the question is, why HB4 and why is the bill structured this way? First, I believe House Bill 4, unlike some other prior proposals, is completely constitutional. It is not in conflict with the precedent set in Arizona versus United States, which this committee has heard about before. We heard testimony on that. House Bill 4 is completely distinguishable from the statute that Arizona passed, Senate Bill 1070, and is not preempted by existing federal immigration law. What Arizona attempted to do back in 2010 when they passed their law is completely different than what Texas is doing under House Bill 4. Second, House Bill 4 is not preempted by federal law because it is not in conflict with federal law. To quote from the majority opinion in the Arizona case, state laws are preempted when they conflict with federal law, including when they stand, quote, as an obstacle to the accomplishment and execution of the full purposes and objectives of Congress, close quote. House Bill 4 goes to great lengths to avoid that. Third, Texas has the constitutional right, authority, and ability to protect its borders. As pronounced by the late Justice Antonin Scalia in his partial concurrence in the Arizona case, neither the Constitution itself nor even any law passed by Congress supports a result that would deprive states of what most would consider the defining characteristic of sovereignty, the power to exclude from the sovereign's territory people who have no right to be there. Fourth, House Bill 4 is the Texas solution to a Texas problem. It is a humane, logical, and efficient approach to a problem created and fostered by the Biden administration's continued failure and refusal to secure our border. Not only does it not overburden our criminal justice system, it should be less costly than detaining many people that we're currently expending funds to house. There is nothing unfair about ordering someone back from where they came if they arrived here illegally. Yet the penalties for intentionally refusing to comply with an order to return are stiff, as well they should be. House Bill 4 tracks existing federal immigration law, the law that has been in place for decades. Further, House Bill 4 protects and supports our Texas law enforcement officers and gives them the tools and the authority they need to help keep us safe. I applaud Governor Abbott for adding this issue to the special session call. Texas needs House Bill 4. Again, Texans must protect Texas, especially when the federal government will not. House Bill 4 allows us to do that. So with that, Mr. Chairman, subject to any questions that you or this committee may have of me, I thank you for your time and respectfully reserve the right to close.
Representative Raymond.
Thank you, Chairman. And thank you, Representative, for, trying. And trying to do something about a big issue. I wasn't trying to be funny. And thank you for visiting with me. We visited one-on-one. And by the way, Is it okay or fair to say the governor's office has been working with you on this? Is that?
Yes, I've worked closely with the governor's office, continue to do so. He had the original call that we've all seen,
Right.
and then he supplemented the call specifically dealing with the issues contained in this bill. And so I think
Okay.
very much so that the
So
governor,
it's fair to call this the Spiller-Abbott bill?
well, you can call it whatever you want. That's fine.
I'm gonna call it the
I'd be
Spiller-
honored, but
I'm gonna call it the Spiller-Abbott bill.
that'd be fine.
Because
Why don't we give the Governor Abbott first calling on it?
all right,
rather
the
than how to
Abbott
do it?
Spiller bill. All right, the
All
Abbott
right,
Spiller
there
bill.
we go.
Per your request. But again, you know, sort of what I started talking about the other day, it's like, what do we want to accomplish? What do we want the end result to be? And I think we're in agreement that what we want is to try to discourage people from coming, right?
Absolutely.
And you know my concerns about the way Senate Bill 11 was written, and even to some extent the way this one is written, and that is that I personally, from what I can tell, being a border rep and watching this stuff for so many years now, this is my almost 30th year in the legislature, and you know, the dynamic of offering people what you're offering them in this bill, what you're offering immigrants in this bill, right? Before I get to that part, let me ask you this. What you do put in here is something that I talked about the other day, which is removal, right? I called it deportation. We talked about it. Say don't call it deportation because I guess we don't want to send them all the way back to their country, which I think would be the most effective thing. If you take them all the way back to their country instead of Chicago, New York, or Washington, they're less likely to come back, and they're not in the United States, right?
Right.
However, if you don't want to deport them, or Governor Abbott doesn't want to go that far, that's going far, at least you reference here returning them. In our case, it's going to be Mexico, because if they crossed in here illegally, it's likely to be from Mexico. It could be from Canada, but it's likely to be from Mexico. That's the big issue, right?
Right.
So, but you put in there May. And as I told you yesterday, what I've learned anything in 30 years is that there's a big difference between the word may and shall. Big difference. I mean, big, right? So, number one, I know you said you'll keep working with us. Chairman, I don't know if we're going to vote on this today. If we vote on this today as it is, I'm not going to vote for it because it's just not good enough. But I'll keep working on it. Because for starters, this bill ought to be a clean bill that says, in my view, the most effective and cost-effective thing is if we catch somebody who comes over here illegally, you return them to Mexico. That will cost a lot less. It will be more effective, right? In my view, that'll be more effective. And if it doesn't work, I'd say to the Abbott part of the author of this bill, that if it doesn't work in 3 to 6 months, call us back in. Then we can try this deal about, putting them up in county and state housing for 6 months or a year or whatever. So now let me move over to what you're proposing in terms of arresting them, right? And it's a little less, the bill we had the other day that Speaker Guerin laid out started with a year. Yours starts with 6 months, right? So what you're proposing is they get arrested. Now they may return them. That's not good.
Well, originally, let me clarify.
Yeah.
Originally, they're detained, and there's a decision made whether they are returned in order to return or whether they are arrested.
And let me say, by the way, because you thank you for bringing that up. We talked a little bit about it yesterday, and I see Director McCraw here. One of the first things I did, I think in my second term, it wasn't even as a bill, it was as a member of the Appropriations Committee. I put money into the budget to help put together the very first statewide database for gangs, so that if somebody got arrested in Laredo, right, my law enforcement, my city police could figure out if these guys were in a gang in Dallas. So I pushed for that early on, and now we have that, right? And so I get that part, and we talked about it, and the director made some reference to it Monday, or whenever it was, Monday?
Was Monday.
That if you have somebody, and because you can look into a database or whatever, if these are bad guys, as we call them, the guys in Nuevo Laredo, we call them los malos, the bad guys. So, I get that part of, okay, maybe this is someone you want to stick in a jail. But all the other ones that don't fall in that category, which are going to be the overwhelming number of people you catch, candidly, the overwhelming number of people you catch are not going to be, criminals, or not going to be gangmen. That's not the way it's going to go. So let me ask you, that person, you catch that person that's not a gang member or whatever, you stick them in a jail. Are they, just for the record, will they get 3 meals a day?
Well, if they're placed in jail, they will, yes,
Will they get medical attention?
if they need it,
Will they get health care?
if they need
Will
it.
they get dental?
Well, I'm assuming they will.
Yes. Will they get clothes on their backs? Will they get
Maybe
shoes
an
on their
orange
feet?
jumpsuit, but yeah.
Will they be prohibited if their TV's there from watching TV, or will they be allowed to watch?
No, they get the same benefits.
They're gonna get all those things. And so you see my concern that for a lot of these people, that's a step up. That's a step up. And by the way, but before they even get to where we start housing them, well, let me finish up. You house them for 6 months, or maybe for a year and a half or 2 years later, right? I believe the way the law works, and you got a big old fat notebook, you've been working on this, so you're gonna know, and you're a good lawyer. They've been in for 6 months, we release them to ICE, right?
Correct.
And what,
After they have some disposition of their case, yes.
right, and what happens when they get to ICE? And they say, I wanna claim asylum, what happens?
Well,
I'll answer
I
it.
don't-
They
okay.
get released into the United
no,
States.
I don't even think they have to claim necessarily asylum. They can, but I think they're released to ICE, and ICE may turn them over to Border Patrol. But in any event, they're assimilated in the population.
They go into the United
Exactly,
States.
unless-
So we're fattening them up for 6 months, right? We're fattening them up, we're making them healthy, we're giving them health care, we're giving them dental, we're doing all this. And we think that's gonna deter people from coming here illegally into the state of Texas? It goes back to what I told you. This is a welcome mat. Welcome to Texas. We are now a sanctuary state. We're now a sanctuary state. We're gonna feed you. We're gonna fatten you up for 6 months. We're gonna give you ICE, and they're gonna release you into the United States. Hell, we might still give them rights to Chicago and New York and Washington for all I know. And I'm trying to be serious about that, because it's a serious issue. And if we want to get serious, you knock all this out. You and the other author of the bill, you knock all this out and you say, you don't want to use the word deport? I would, but fine. You don't want to go that far. Maybe I'm just too conservative. I would deport them back to their country, but fine. Send them to Mexico. And by the way, when we start doing that more and more and more and more, you know what Mexico's going to do? They're getting a new president next year. You know what? And it's going to be a woman, by the way. You know what they're going to do? They're going to enforce their southern borders, because they're going to say, hey, Texas is putting these folks all back into Mexico. We need to do something about our very loose, Mexico needs to do something about their very loose southern border. But if we're doing this up here, I promise you, that's what's going to happen. They're going to start enforcing their immigration laws in their southern border, because we're just pouring in, and their border cities are already stretched too. Matamoros, Reynosa, Nuevo Laredo, Ciudad Acuña, Piedras Negras, Juarez, they can't take all those immigrants. Right. They can't. So, with all respect, I mean, I get when people want to say, oh, I know you, and I know you're doing this, and you're trying the best you can, and I appreciate you. I love working with you. Even though, for the record, let me say, Representative Spiller is probably the most conservative member in the House. And if anybody runs against them, they're liberal. But anyway, but I appreciate what you're trying to do. I'm trying to get to a real solution. If we are going to jump in, as I told Chair Niave, is she here? I'm here. As I told Chair Niave, she chairs MALC, Mexican American Legislative Caucus. If we have decided as a state that we want to make a statement and do something to affect illegal immigration, whether you agree with it or not, but if we're going to jump into that, then let's do it, and let's do it right. Your bill is almost there. It's not quite there. Don't offer to fatten them up and give them free food and health care. Give them a notice. You pass this, we're going to take you. Not may. It's going to be a shall.
Well, let me respond to a couple things. One, I think you and I are on the same page generally, that we want to return them to the place from which they came. And so this bill, and I respect that, but the focus of this bill is not to punish. The focus of this bill is to do exactly what you want, and that is to put them there. It's listed as may for several reasons. number one, has to do with constitutionality reasons, in my opinion. But number two is it gives DPS and law enforcement some options because some of these folks, you don't necessarily want to return.
But let's write that in there.
Right.
Let's write that in. That's why I was getting to that. Thank you for revisiting it. Let's write that in, that when they arrest them, because they're going to arrest them, right? They're going to get them. When they arrest them, if they find out that's a gang member or whatever, hey man, put it in the bill that person is going to be dealt with differently. But that's not going to be the overwhelming number of people that you
No, it's not. No, it's not.
That's not who you're going to get.
No, it's not.
So, but put that in. I'm good with that. I'm all for it.
Well, that brings me to the second point. And normally, and you know me, and you call me one day and you want to meet, and I'm going to meet with you that day, and I will meet with anybody at any time about any bill that I carry. I mean, if you know me, that's the way I roll. And partly because I want us to have the best piece of legislation we can possibly have. I want good law, I want good policy, and I'm willing to listen to folks to do that. And the other folks in this room that I've talked to know that, and many of which I've already visited if they've expressed concerns. We've talked about those things, and we're looking at some of those things. But I'm somewhat limited here because rather than this is just my bill that I pulled out of the air, I'm working closely with the governor's office.
Right.
And we're somewhat limited because there are other things that we might otherwise include in the bill, but because of the bill caption and the way that it's styled and the way that it's structured, I don't want to create problems and points of order. I don't want this to go away because even under your scenario that you don't really like it in its current form, I think it's still darn good policy and we need to do it. And I think you might agree to that as well. And so we need to do that. But I'm also limited because we're in a special session and we're limited as far as the call and those type of things. So what I'm saying is I'm trying to do the best I can to get us where we want to be. And I'm open to suggestion and I'm open to ways, and I'm working actually with folks right now to try to fine tune this, to have perfecting amendment, one or more if necessary, to get the best bill that we can.
Well, but for starters, because the governor's involved, and that's an easy fix. He can reword the call however he wants to cover the bill. Second of all, you already have in here that they may be returned, so you're not worried about a point of order on that. So you're already in there. You're already in that, and what I want to get to, right? So, but if the governor needs to change it to say the legislation that may include or can include deporting or removing from Texas, he can put that in. That's an easy fix. But in your opening, you talked about you want a humane solution.
I do.
Humane solution. That's where you sound like
I want to.
That's where you sound like a Democrat.
Rather than incarcerate people. That's what the purpose of this bill is.
Wait, but you're incarcerating them.
No, not necessarily. I'm not. I mean, that is an option.
What do you mean? Not necessarily.
No, I mean, these people, if they're apprehended crossing the border illegally,
yes,
they will be, their identifying information will be collected,
right,
and they will be turned over to Border Patrol, and they will be ordered to go back to Mexico. They are not being locked up for 6 months. That's not what this bill says. They would if they're prosecuted, the same as they would if they're prosecuted for criminal trespass or something else.
So to be clear, under your bill, Webb County Sheriff's deputy gets somebody, they crossed, they're illegal, whatever. So they cannot arrest them and go put them into the process where they can end up in jail?
I'm saying that under the wording of my bill, they're detained. They're not technically arrested. They're detained, and their identifying information is there. Now, we're working out the logistics about how we identify those folks and do some of those things to make sure we know who it is and make sure if we have a reentry problem that we can deal with that. But those folks will be taken to a port of entry. They will be instructed to leave. If they refuse to leave, then they would be prosecuted for secondary felony. But if they agree to leave and not come back.
Now I'm confused. Where does it say here that they're going to be taken and they're going to be instructed? They will be.
That's under.
They will be, not they may be.
51.02, Section E. In lieu of arrest, remove a person detained.
Okay, well now, okay, let me see. Where?
For a violation by collecting their identifying information, transporting the person to a port of entry, and ordering the person to return.
But it gets back to, you talking about line 17, subsection E? Line 17 on page?
Yes.
Okay.
That's the one for entry. There's a second provision further in for reentry.
But again, the fourth word is may, a peace officer.
Oh, I agree.
Well, then don't say that they're going to, because that's not.
Well, that's the intent. That's what is
Well, then,
intended.
if that's the intent, why don't we change it to shall? Because May is that,
Well, frankly, because
you're worried about
we
a
run
federal
into a
lawsuit?
situation, if, in the event that we have future problems with getting them back to Mexico, that requires some cooperation, and we think that we have that now. But there, I mean, it gives law enforcement some options and some ability based on the individual circumstances of each case. And so, I believe that having the May language, this is the intent. This is what is the desired result, is to return people back to Mexico.
Again, you're still not getting me, and I need to move on so other members can ask you, but why will you not put shall?
Shall potentially creates problems. It creates constitutional problems with enforcement of.
Whoa, constitutional problem. You're worried about a federal lawsuit? You're worried about?
Well, I am worried, I
You're
am
worried about Biden
concerned.
suing you?
I,
You don't
no,
want
I'm
to
not
put
worried
shall?
about anybody suing me, but I am concerned about, to make sure that this bill is clean as far as from a constitutional standpoint, and I believe currently it is. But when you have, I don't want to get into the weeds on it, but when you have the punishment of a potential, of a criminal offense being something other than only, return someone, I think there's a problem there. And also, I mean, I just think it's this is the way it's drafted.
Let me just say respectfully.
Right.
If you're worried about a constitutional problem where you're saying, hey, it's our intent that that law enforcement officer is going to take them back, but as long as we don't say that they are going to take them back, we think we're okay constitutionally. So we'll just say that they may take them back, although that is our intention, that they will take them back.
Right.
There's no difference in my view, and if you're
Well,
in court, I don't see how there's going to be a difference.
I
So
respect-
let's do the full Monty.
I respectfully disagree.
Okay.
But I do think that this gives law enforcement options. I've already explained what the desired result is. The result here is not to incarcerate more people. That would create a problem from a cost standpoint and all that. That's not what this bill is designed to do. This is as a measure in part to save cost and save expense, because those folks that you would otherwise incarcerate, either under this or under criminal trespass or anything else, you're alleviating that if they haven't otherwise committed a more serious criminal offense, that they could be returned to the port of entry to go back to the country of origin. So that's the desire, that's the purpose.
Now you're kind of like saying, well, no, we're going to put in here that we're going to arrest you and put you in jail, but we're not really going to.
No, I'm saying we still can. That's the whole point, is that law enforcement will have options to be able to do that under the particular circumstances if they need.
Can you, and what do you envision in terms of, I've done this in town hall meetings all the time. Somebody says, there ought to be a law. So you're saying there ought to be a law, and this is what the law should be. So how do you envision that my sheriff deputy gets this person, takes him to the bridge, say, you got to go? No, I'm not going to go. No. Well, if you don't go, I'm going to take you over. We're going to prosecute. You could be in jail for 6 months. Okay.
Well,
I'm not
if
walking
they
across
refuse to
that
go,
bridge.
they're not going to be in jail for 6 months. They could potentially be in jail for up to 20 years. So I really don't think they're going to choose.
After the second time.
What's that?
After the second time.
No, sir. The first time. They can be charged with the offense as an option. They can be charged, which is a Class B misdemeanor. Their refusal to comply with an order to return is a second-degree felony, punishable by 2 to 20 years and up to a $10,000 fine.
And so you think, so in fairness to you, you think that we're at the bridge, they start walking, no, I don't want to go. All right, well, you know what? You're resisting, you're not doing it. Now I'm going to have to take you in, and you could get up to 20 years.
That is true.
You might just get 6 months, or maybe 2 years, I don't know, or 1 year, 2 years, is that right? 2 to 20?
2 to 20.
Yeah, so you could get 2 years, but it could be up to 20. And so your view is that that's going to be the deterrent.
Yes.
And that they're going to turn around and walk across.
Absolutely.
Thank you for
Sure.
letting me ask a few questions. I appreciate you.
Vice Chair.
Thank you, Mr. Chairman. Thank you, Representative Spiller. I had a few more clarifying questions from Representative Raymond's questioning. You said it's worded as may for constitutionality issues and giving law enforcement options. So are we concerned about lawsuits and perhaps violation of not only the federal laws, but our Texas Constitution as well, specifically Article 1, Section 20, which states, no person shall be transported out of the state for any offense committed within the state.
Okay.
Is that what your concern is?
Okay, well, let's go back. I'm not saying anything under our state law. They're not transported out of the state. They're taken to a U.S. port of entry, and they are ordered to go back. They can either choose to go back or not choose to go
Making
back.
that order?
What's that?
Is the peace officer making that order in the law?
Yes, yes.
So we're ordering them.
They're ordered to go back.
Okay.
They can choose to go back or not go back, but they're ordered to go back at a U.S. port of entry. This bill has nothing
Bill
to do.
talks about removal, though. It doesn't talk about taking, it says
No,
maybe remove a person
I think they're
in lieu of
ordered,
arrest.
ordering the person to return to the foreign nation from which the person entered or attempted to enter.
How
So
is that not
it's
removal?
different from, it's different, it's styled after the removal statute that's in the federal statute under 8 U.S.C., but it is, it's not a formal removal as what the federal government has. They are ordered to return.
Okay.
The,
But we're doing the same thing. You're saying in lieu of arrest, we're taking you back.
well, I don't think it is the same thing, because one, they have a choice. Under a removal, under federal law, they don't have a choice. They are removed. The federal law enforcement will remove them, period. That is going to happen. Under this scenario, they are ordered to leave, but it's not a formal removal under federal law, and it's not a formal removal even under state law. They're ordered to leave, to return. They can either do that or not do that. If they do that, then they go back, and that end of story. If they don't do that, then they can be prosecuted. They can be prosecuted for the removal. They could be prosecuted just if for whatever reason, law enforcement gives the option that they may say, look, we don't really want to charge them with the other offense as far as refusing to comply with the order to return. We may just want to charge them with illegal entry, which is the Class B misdemeanor. I can't really say under what circumstance they would want to do that, but at least law enforcement has that authority.
Jose, a law enforcement officer wouldn't be transporting an individual, let's say, into Mexico, right?
What's that? Run
A
that
law
one.
enforcement officer, if they detain someone, they wouldn't be transporting them to Mexico.
They're not,
Just take them
no.
to the border. So the effect would be the same.
Well, if someone goes across, the end result is the same. They're back in Mexico. But it's a different process because one, under a removal under federal law, is going to happen, and law enforcement, federal law enforcement does that. Here, again, someone can either go back or not go back. That's their choice. If they go back, then there are consequences for that. If they don't go back, then there are consequences for that as well. But they have a choice whether they comply with that order.
Explain to me the removal order within your bill. What does that entail? If you're saying it's different from the federal process.
Well, the removal is under 8 U.S.C. 1231.
But that's
And
federal law, so.
that's
our
federal law.
Texas law enforcement officers are making a federal law order?
No. It's not a formal removal. Again, under that statute, it is an order to return. That's different than a federal removal order. Under federal statutes, under immigration law, a removal order is a completely different thing. And there are guidelines under 1231 that provide for that, and other statutes as well. But here, it's just an order to return. It's a simple thing, an order to return. It's not in conflict with the removal. It's not a removal. We're not removing anyone. If we, as the state of Texas, were actually removing someone, in my view, that would not be proper. That's not what we need to do, because that could be construed in violation of federal law and in conflict with federal law. But
We're just
here,
issuing these orders, but not doing anything.
what's that?
You're saying we're just issuing these removal orders, but we're not doing anything?
We're ordering them back.
But we're not going to transport?
We're not, we will respond. I anticipate that law enforcement will respond whether they comply with that order and return, or if they don't. But it's not a removal. It's an order to return.
And my next question is, how will these law enforcement make a determination of who has lawful presence? For instance, I see here,
I think they would
the
do it
bottom of
based.
page 1, it's an affirmative defense to prosecution. Affirmative defense to prosecution, so you're being prosecuted already, if you're a DACA. So these DACA young adults are going to be arrested, and then they
No.
will have a defense
They're going to be
prosecution.
detained, which is completely legal. They're not arrested, they're detained. And, but yes, if they are criminally charged, it's an affirmative defense that they could raise that, hey, wait a minute, we're not entitled to be charged because we we raise one of these affirmative defenses.
And all this
that
is going to happen on the side of the road?
What's that?
All this is going to happen on the side of the road?
I doubt it. No.
So they're gonna
But
take it in.
but I think, typically when you raise affirmative defenses in a criminal case, it's after the case is actually filed and you go through that process. Here, if there's some way to determine and identify these folks, if they're here under DACA, that is probably readily known and available, that information. So it's a different situation. That's why I'm saying it.
How is that readily?
They may have that documented. I don't know. I haven't seen any DACA documentation from anybody, so I can't really speak to that.
All these law enforcement officers are supposed to know this whenever they.
No, I don't know if they have any documentation on them or not. Technically, under federal law, when you come over and you're an alien, as that term is defined under federal law, you have 30 days to register, and you're required under federal law to have that paperwork and that documentation on you. This is not the Arizona case. That's what they got into. This is not that at all. But technically, they are required to have that documentation on them if they're here as aliens until they're U.S. citizens.
I mean, I guess as U.S. citizens, we are required to have our driver's license as well, but there are times that I think everybody at this dais has forgotten their driver's license at home. And so my concern is when you're on the side of the road, I mean, how many resources are going to be used for individuals that do have lawful presence here? And what this is providing for is an affirmative defense, but as you said, that's after they've already been taken in.
And I think the whole purpose is to exclude anyone that would otherwise, so as not to conflict with federal law. The entire purpose is to exclude from prosecution or any unintended results, to make sure that people that are otherwise here, whether they're legally granted authority to be here, whether they've been granted asylum, whether they're DACA recipients within the timeframes of DACA when it was created and when it was stopped, any of those things. And I trust law enforcement to look into the totality of the circumstances and make that decision, whether it's on the side of the road or wherever it may be. They make those decisions all the time about whether to detain someone or not detain someone. And so I think certainly that this gives them the leeway and the ability to make those decisions.
You mentioned law enforcement, and that the way the bill is languaged, you include peace officers, and that's a very long list of peace
Right.
officers within the state. For example, including the Officers Commission by the State Board of Dental Examiners,
Right.
investigators employed by Texas Racing Commission. Do you envision them being involved in the enforcement?
I don't anticipate any scenario where the State Board of Dental Examiners would be detaining anyone for illegal entry. I can't really see that, but all law enforcement is provided the same protections here, and so they're listed accordingly. Likewise, I don't think the Board of Managers of the Dallas County Hospital District would be involved either. But
Then
this
why is
covers
it- why
all,
isn't it defined?
because they're all defined as peace officers under the Code of Criminal Procedure under 2.12. So that's why they're listed. They're all entitled to the same protection. I would imagine in the application of this that most of these instances and encounters would happen within 100 miles of the border. I don't anticipate this, and we've talked about this. I don't anticipate this happening in other parts of the state necessarily. I'm not saying it couldn't, but you run into a proof problem to determine when someone actually, when they actually crossed, because this is still a misdemeanor, okay? So all misdemeanors have a 2-year statute of limitations period. If someone is here, and this is what Arizona got into, where Arizona law, the problem was, it was just they were picking folks up or the application would be at any time if they're here illegally. Well, that's not what this bill does. It is
does
set
say
at
that.
a definite time, and it's not like the bill that you heard the other day, where the second component of that, as is under 1325, is if you're ever even here illegally or improperly. That's the concern with that bill. This bill doesn't have that. The trigger mechanism.
But page 3 at the top, it says, at any time found in the state. So
Were
that
you
is
were you looking?
statewide anytime.
Were you looking?
The top of page 3, line 1
That's
and 2.
for
Illegal reentry.
reentry, yes. I'm talking about the original charge on illegal entry. Reentry is a different deal. Reentry is an entirely different deal. But for
So
entry.
it is statewide and anywhere in the state.
Yeah, it's still a statewide offense. This is not one of these where we're trying to limit it to an on-view offense of somebody actually crossing the river. That's not what this bill does. But, law enforcement can make that determination whether they believe. I mean, let's be realistic. There's a someone's charged with burglary of a building. Okay, well, the odds are law enforcement didn't see anybody burglarize the building. The odds are that they got information, they followed up on it, they interviewed people, they got statements, they did other things, and they came to a clear understanding of this defendant burglarized the building. They didn't see it, but they know that it happens. By the same token here, they can still charge someone. We do it all the time. We charge people and sometimes convict people for crimes that law enforcement does not actually on view observe. It's not like a DWI that they pull someone over at the side of the road.
How are they going to know that? Let's say someone's at the grocery store. How are they going to know that someone has re-entered?
Well, again, that's a proof
in a
problem.
store in Dallas.
Because if they charge them with this offense, the burden of proof is still on the state to prove each and every element of the offense beyond a reasonable doubt.
How's the law enforcement officer going to decide that? How is the law enforcement officer going to decide that? How they're going to enforce this bill?
Well, I think through law enforcement, through the officers, they're trained. That's why we've got certified peace
Is there
officers that are
training
listed here.
included in the bill?
There will be training. I can't imagine there not be.
It's
There'll
not
be.
included?
That's not this bill. But I can't imagine that they would pass this bill and it not be implemented without some instruction and training to law enforcement officers. Simply because, if nothing else, it's a slightly different approach than any that we've ever had or any that I've ever seen. So I think certainly there would be training, but no, law enforcement officers are used to looking at the totality of the circumstances to determine who they're going to charge and what they're going to charge them with and why. And so I trust them to make those determinations.
Thank you.
Together with prosecutors as well. It's not just the law enforcement officers.
Chairman Thompson.
Representative Spiller, how many new persons are we gonna have to hire to help to implement this bill?
Well, it's been a group effort. We've gone through several different drafts of it and trying to come up with just the right bill. So, and like I say, I'm still open to address any concerns that people may have. I'm easy to talk about that and willing to look at those things.
Well, I noticed we're looking at, being able to stop people, detain them, and then send them back. So that's gonna take some personnel. Do we know how many more people we're gonna have to hire?
I don't know that this bill contemplates or even requires additional personnel for enforcement. We've got law enforcement DPS on the ground now that are through Operation Lone Star and through other efforts. We have folks there. This would be a tool for them because right now, my understanding is this. Unless someone sees an on-view offense of some more serious offense, such as a felony or something else, and they charge them with that, then generally, law enforcement right now, if someone comes across illegally, this bill, again, clearly doesn't have anything to do with legal immigration coming across U.S. ports of entry. This does not affect that at all, does not have anything to do with that. It's only about people coming in illegally between U.S. ports of entry. So right now, if someone crosses the river and they're on public land, generally DPS is going to detain those folks and take them to Border Patrol. Border Patrol is going to process them, assimilate them. To my knowledge, unless they're not admittable, I'm sure I gave the wrong terminology there, but if they're not allowed in under other reasons, then they are processed. Even those that come across illegally are processed and assimilated into the population.
We're anticipating, we're not anticipating an increase in those persons, right?
Right, but on the exception is if those folks go beyond that public access once they cross, and then they get on private land, they can be charged and are being charged with criminal trespass, which again is a Class B misdemeanor, the same as this. Those folks are being detained. We're all paying, either the state, county, or both are paying for the bed space, the cost to feed those folks, the cost to provide medical care, the cost of an attorney, the cost and the burden on the judicial system. All of those things are happening.
Raymond expense.
Right.
Okay.
And so
Now,
that's
let me ask you this question. May I ask you this?
right.
Okay. Then we're not anticipating an increase in those number of persons, right?
I think that we're taking those folks now that come across and are in a public area, we're taking those to Border Patrol right now. So those same people will be transported to Border Patrol at a
We
U.S. Border.
anticipate an increase in that number.
I think you're still going to have the same number, but
Okay.
the difference is those people are now, instead of being assimilated into the population, are going to be ordered to return. So we're not.
Now, can you tell them to return to their destination or just get out of the country, get out of our country? You can't make them go back where they came from.
I can't.
No, you.
No.
Only thing we can
Well,
do-
either, make sure we're talking about the same thing. Going back to their original country of origin, that's a different matter.
Right.
But whatever it was, if they came from Mexico, in reality here, we're dealing with
In other words,
Mexico.
we evict them out of Texas.
Correct. And Mexico allowed them in from someplace somehow, or they wouldn't be here for the most part. And so, although technically this bill is broader than that, but Mexico let them in. Mexico can take them back. And frankly, the governor has a memorandum of understanding with, there are 32 states in Mexico. Just like we have 50 here, they have 32. 4 of those are on the U.S., on the Texas border. And our governor has memorandums of understanding dealing with border security with each of those governors in each of those states. And so there should be, and that where they have agreed to cooperate. So I fully anticipate that they would accept them, take them back, and what they do with them from there is their business. So
Where does the money come from to fund operational Lone Star?
I'm sorry.
Where does the money come from that funds
Oh,
Operation Lone Star?
comes from you and me and the taxpayers of Texas.
This is all Texas dollars.
Yes.
Okay, no federal money in here.
I wish we did have some federal money spent on our border security. Then I wouldn't be up here in front of you right now.
Okay, thank you so much.
Thank you.
Representative Turner.
Thank you, Mr. Chairman. So, Mr. Spill, how will a peace officer, since that's the term in the bill, how will a peace officer know that someone unlawfully entered the state?
I think they look at that, again, as a totality of the circumstances. If it appears to them that, obviously, the closer you are to the scene of the crime, the more likely it is that may have been where it occurred.
Well, specifically, if I'm a peace officer and I'm interacting with an individual, how do I know that this person is here unlawfully?
I think to fully answer that question, you would have to talk to DPS officers because that's what's going on right now.
I presume you've talked to some law enforcement
I have.
officers if you've written the bill. So
Right.
what have they told you about how they would?
Generally, they look at the totality of circumstances, the circumstances under which those folks have been detained and are questioned. And that's happening right now when they see groups of people coming across and they're coming cross-country right at or near the border. They've got their clothes with them. They're from another country. They can't produce any of those things. The odds are they got here illegally. So I think that they're making those determinations on the scene based on a number of factors.
But you said a minute ago that unlike the bill we heard the other day, there's no requirement in this bill that a law enforcement officer witness someone crossing the border, correct?
Correct.
That's not in this bill.
No.
So if someone is present in this state, anywhere in this state, unlawfully, they could be arrested under this bill.
I don't believe so. And the reason I say that,
Where in the bill does it say they can't?
well, it doesn't in the bill, but clearly the charge for illegal entry is a Class B misdemeanor. The statute of limitations for that is 2 years, unlike a felony. And so this is not addressed to someone that has been here 5 years, 10 years, 20 years.
So let's say they've been here 2 years or 1 year.
Yeah,
Okay, so say someone's been here 1 year, they're in Arlington,
yeah.
and an officer suspects they're here unlawfully. I mean, they could be arrested and or removed.
Within that 2 year period, that is possible, although I don't know of too many prosecutors that would want to take that case knowing that they can't prove where they came from, how they got here. Granted, if the people didn't apply and report within the 30 days as they're required under federal law, whether they did or whether they didn't, whether they got here, illegal. I don't know. I can't imagine any prosecutor wanting to take that case if they can't prove the elements of the offense. prosecutors have other things to do and prove cases that they can prove in court. And here, the farther you get away from geographically and the farther you get away from time, I think they would have a very difficult time proving each and every element of the offense beyond a reasonable doubt.
Sure, but the bill doesn't so much speak to what prosecutors are to do. It speaks to what law enforcement officers are to do, right?
That is true.
So, I mean, a law enforcement officer could, trying to, in good faith, enforce this bill, should it become law, say, well, believe this person is here unlawfully under House Bill 4. I've got the authority to detain them, arrest them, order their removal. And so what is to discourage or stop a law enforcement officer from doing that? It seems like we're it seems like that is the purpose of the governor's call, the modified language in the call that we saw this week.
Right.
Is to do exactly that. I mean, am I wrong? Is that not the purpose?
Well, I think the purpose is to stop what's going on right now at the border. The purpose is not to incarcerate everyone here in the state of Texas that may be here illegally. Technically, that's not, even under federal law, that's not really a violation of the law. That's what Arizona tried to get into and what they did. That's not the purpose of this bill at all. And I think you would have a very difficult time proving that. And if I get your point, but that's not the purpose of this bill.
So what happens if a law enforcement officer believes someone is here unlawfully, they arrest them? Well, let me ask you this way: how do you envision the process unfolding? So a law enforcement officer suspects someone has entered the state unlawfully at some point in time. They don't have to witness it, so it could have been today, it could have been 6 months ago. What happens then when they suspect someone has entered unlawfully?
I would think that they look at, again, the totality of the circumstances, decide whether a violation has occurred, and decide whether it could be provable of each and every element of that offense beyond a reasonable doubt. If so, then they can take them to a port of entry and order them to return.
Okay, so when do they make that determination? Is that the arresting officer or the
I can't speak
detaining
to
officer?
that. It could be the arresting officer. I would think if they have questionable, if you have a circumstance that's somewhat different, they may check with supervisors. They may visit with prosecutors. There are a number of border prosecutors that are dealing with those type issues.
Do they do this while just detaining someone either on the side of the road or in a public space, or do they take them in somewhere to begin this determination of their status?
They could take them to one of their processing locations. They could question them there, interrogate them just like you would under any circumstance to determine whether a crime has been committed or not, and make a determination at that point based on the totality of the circumstances. And they would probably, I would think, if there's any question, especially if it's something that's not readily apparent to them, they may very well visit with one or more prosecutors to say, hey, do we really want to do this, or do we just want to cut these folks loose?
And so is it required then that they talk to a prosecutor? I mean, can they just say, I believe that you're here unlawfully?
No.
And I'm ordering you to return, or I'm going to take you to a port of entry right now. I mean, do they have that authority?
They do.
Okay, so there really doesn't have to be an involvement from the prosecutor.
They don't have to talk to a prosecutor. No, they don't.
Okay, so that goes back to my original question. I mean, you said, well, I don't think prosecutors would want to prosecute that. Well, the prosecutor doesn't have to be involved under the bill, right?
Initially, no.
Yeah. So back to my example in Arlington, if a law enforcement officer believes someone is present illegally or has entered illegally in the last 2 years, they don't have to go to the Tarrant County District Attorney's office and say, what do you think? They can say, get in my car, we're going to a port of entry.
True, but they can do that right now on any offense that they want to, as far as incarcerating someone or taking someone to detention. They can use a probable cause affidavit. They can do whatever.
Sure.
Or if they have an on-view offense, and they can incarcerate someone anytime they want to.
To detain them in a county jail or city jail.
Correct.
But not to return them to
No,
a
that's
port
true.
of entry.
That's true.
Okay, so that's a totally new thing.
Different.
That we're doing in this bill, and it does not involve a prosecutor. Doesn't have to involve a prosecutor.
Doesn't have to.
Okay, so So in that situation, you said the officer would look at the totality of the circumstance to make that determination.
Yes.
What does that entail? What's part of the totality of the circumstance?
Well, I think certified peace officers could to speak to that entirely, as far as they look at they look at the what they see at the scene. I would think they look at the people that are there, what identifying information that they may have on them. They may look at where they are, may make a difference, whether they're in the middle of some field somewhere that they have otherwise no right to be there. They may question them. They may get statements from them. They may seek some conversation with them to see, what, ask them questions, just like they would interrogate or question anybody in any situation like that if they feel that any criminal offense has occurred. They have the right, based on probable cause or reasonable suspicion, to make a stop or a detention and ask those folks questions. So that's nothing different here than what you would there. They're looking at the totality of those circumstances to determine whether they feel that a criminal offense has occurred, and if so, then they look at the different options that they have, one of which would be to incarcerate them, but the first and foremost would be to return them and take them to a port of entry and order them to return.
Okay. So basically, the officer will employ a variety of methods
I
based
think
on
so.
how you described to basically determine the person's legal status.
Yes.
So they'll make a determination as to whether this person is a citizen, a permanent legal resident, or an undocumented.
They may not make a total decision, but I think they could have a pretty good indication whether whatever category that they fall in, and which, by the way, that aspect of the Arizona case was held to be constitutional, that law enforcement has every right to make that determination and look at that. There were some other aspects of the Arizona case that they found unconstitutional, but the portion that they upheld was exactly the portion that you're talking about.
So basically, this could, you said a minute ago in talking to Vice Chair Hernandez that you think that the majority of these actions would take place within 100 miles of the border?
I think that's where I see, when I've been to the border, on the many times I've been there, that you see the greatest concentration of DPS officers because they're trying to protect that area. They're trying to protect and stop illegal entry. And so most of those folks, I would say, are within 100 miles of the Rio Grande River. That's where most of these things are.
Most of what folks?
Most of the people that they are having encounters with are there. They're not in Texarkana. They're down on the border. And I would expect that the application of this bill would be primarily, not to say it's limited to that, it's open to the entire state of Texas, but the focus is on the border, and that would be where they would be most likely to have a case that they can prove.
But it's also not just limited to DPS officers as well.
It's not.
Right?
All law enforcement.
Any
That's
peace
correct.
officer, right? Okay.
And, which include, we've got Texas National Guard, we've got other folks here too under operational.
So, but it could be anywhere in the state, and it could be, someone it could be in a supermarket, someone in a church, someone in a shelter. A peace officer would have the authority under this bill to, if they make a determination that someone's here unlawfully, they would have the ability to return that person to a port.
If they feel that someone, if they feel like they can prove, and that someone entered, it's an alien that entered the country illegally at a location other than a lawful port of entry, then yes, they would have the right to detain them and return them to a port of entry.
Okay. So what would happen in an instance where someone, say, is a green card holder, a permanent legal resident, who has protected status, but they don't have their documentation on them? Could they be arrested?
Well, I think they could still provide that identifying information. They would say who they are, and those folks could verify that. I don't see this as an attempt to go after folks that are holding a green card or that.
Yeah, and I'm not saying that's your intent. I agree, but technically under the bill, if someone can't prove that they're a citizen or a legal resident, doesn't the law enforcement officer have the authority, express authority under the bill to immediately return them to a port of entry?
Again, they have the right if they believe that a violation of criminal law has occurred, but clearly those folks have a right to be here. Whether they're still, the question is, are are they still classified as aliens? And I don't know that I can answer that question. I'm not enough of a immigration law expert, although I've spent a lot more time on it lately than what I ever thought I would. But if they're still classified as aliens, if they have a green card, or if they're not. But it may be a different classification or different status. But nonetheless, I don't see law enforcement gathering up folks that have a green card to return them to a port of entry and ordering them back to Mexico. I don't see that happening under this bill.
And so with respect to port of entry, you define port of entry in the bill, means port of entry designated by federal
Correct.
law. So,
Yes.
so is an airport a port of entry under the bill?
It may be, let me look, there appear to be, I don't want to read, it's a long-winded definition. I do know that there are a number, I think there are technically 21 ports of entry in the U.S., and some of those may
In
include.
the U.S. or in Texas?
I mean, I'm sorry, in Texas. There are 21 that are listed under that statute, and so some of those may have to do with international airports. So I think it would be. So that might be more expensive to return to Mexico if you send them to DFW Airport, but I don't think, again.
So we'd be on the hook for the plane ticket, right?
Right.
Yeah.
So,
But conversely, if you using the DFW airport, for example, just keeping in our general part of the state, then you're talking about the expense of transporting someone, hundreds of miles to South Texas, presumably, to a port of entry. I mean,
Right.
Would that expense fall on, let's say, keep it in, it's a Tarrant County example, would that fall on the Tarrant County Sheriff's Office or that police department, or would that be absorbed by the state?
I would imagine that would be a state offense. I can't imagine
No, of expense.
a state expense. I can't imagine that being Tarrant County's expense to fly someone to,
Or even to drive them.
right.
So local law enforcement would be able to bill the state for expense?
Not under this bill. There may be some reimbursement procedures currently that we have in place under Operation Lone Star. I don't know. But that's not really the focus of this bill, and that's not what's contained in this bill.
And then just to follow up quickly on your conversation with Vice Chair Hernandez, you said that the bill speaks to an order to return, not removal. Did I understand that right?
Right.
Okay. But the term remove a person appears in the bill. Like, if you look at page 2, line 17, a peace officer may, in lieu of arrest, remove a person detained for a violation of this section. Then appears also, I believe, at the bottom, page 3.
Right. It does have the word remove in there, but the actual order is the order to return, and that's the focus of it. I'm not saying the word removal doesn't appear in the bill. It does, but it is not the same process as removal under federal law.
Okay. All right, thank you.
Now, members, I know we have some more questions. I'm going to encourage at 2 o'clock, because he'll have been up here 1 hour. And we have a block of time for the witnesses, and we have several. And we have one of the resource witnesses that we need to get up. So I just kind of want to tell you, so I'm going to try to encourage you that anybody else, I know we have some here, we stop at 2. Go right ahead, Representative Nyavi-Creel.
Thank you, Chairman, and thank you, Representative, for laying out your bill. Can you tell us, let's say that you have a mom who has her infant child with her that's crossing the border. Under your bill, the mother could be arrested or deported, correct?
All right, so that gets into this issue about options. Law enforcement has the authority. They could, if they thought as a family unit, this bill is not intent on breaking up a family unit. They could either order those folks, take them to a port of entry and order them back. They could, if someone is an adult, they could charge that person with illegal entry. There are a number of things they could do, or they can still do the same exact thing that we're doing right now, and that is turn those folks over to Border Patrol and let them process them in the due course that they typically would. So those are the options that law enforcement would have, and out of fairness, and I like I say, this bill is not to be vindictive. This bill is not to be hateful. This bill is to be efficient and more humane and more compassionate than what we're doing right now. And so that's the focus.
Thank you. And let's say that the peace officer chooses to arrest the mother. What then happens to the infant child?
I don't know. Probably the same thing that's happening right now. If we incarcerate someone that is a parent for whatever reason currently, this does not change that process. This does not change that procedure. I don't know if Department of Family Protective Services is involved or not. But typically, when my discussions with DPS on that very issue have been that, look, we don't want to leave a minor without a parent. So in any circumstance or any process, as Texas, we can't control if we find children and they don't have a parent with them, we have to deal with that situation. But every time I've talked to DPS, they've made it very clear to me that, look, we're not about separating, parents and taking parents away from children. That is not the purpose of this bill, and that will not be the implementation of this bill.
Okay. But it doesn't have language in here prohibiting the separation,
It
right?
doesn't, but we're not doing that right now.
But it could
as well.
happen. It did happen under the Trump administration. So families were separated, and then the children were sent to the Office of Refugee Resettlement. And so you're saying that that's probably what would happen here is if a mom was arrested, in that case, the child would go to the Office of Refugee.
I don't anticipate a situation where I've been reassured by DPS that is not what they want to do. They do not.
But there's also local law enforcement, so it's not just DPS. So even if that's
true.
DPS's choice, so local law enforcement could arrest mom and separate her from her infant child.
It's possible, but I don't anticipate that happening.
And so, and I'm sure you can imagine how strenuous of a process that was for parents whose, children were taken from them. And are you aware that there are still hundreds of children still waiting to be reunited with their parents since being separated back in 2017?
Well, as I said, we have a crisis, and we're trying to address this as best we can to minimize the number of people and therefore the number of children that come across our borders illegally. That just exacerbates the problem. This bill is directed to address that problem and minimize the folks, and if nothing else, to act as a deterrent to others to come across when they know that this would be the result.
And you're saying it's not your intent to separate families who are trying to seek freedom? Okay, and in those cases where they are separated, is the state going to be in charge of reunification under House Bill 4?
Whatever law that is applicable now will continue to apply. This bill does not affect that at all. So I'm not an expert on what all is being done now, but I do know that this bill doesn't change that law. I'm hoping that as a state that we're dealing with those problems and those issues as best we can. But this bill doesn't address that.
Thank you.
Representative Lopez.
Thank you, Chairman. Representative, I'm from South Texas. I'm right at the border in Cameron County, where we do have hundreds and sometimes thousands of immigrants coming through. I saw some statistics recently where we were getting 300,000 a month coming in. So let me ask you a question. You kind of answered this already, but I just want to make sure that I'm clear on my understanding. When it comes to law enforcement stopping a person, do they just go up to anyone and say, hey, come here, I need to ask you something, Or what determines when they are going to approach a person, when law enforcement is going to approach a person, and what determines that?
I don't really see anything different from what we're doing currently to what we would do if this law passes. Yes, it's a separate and new criminal offense, but law enforcement is approaching these people now that are coming across illegally, and they're processing them. They're making determinations whether other more serious crimes have been committed. They're making determinations whether lesser crimes, such as criminal trespass, are committed. In the event that they're not, then they're processed accordingly, and they're taken to Border Patrol, which eventually they're taken to a port of entry. I don't see any of that changing. I mean, so I think, to answer your question, the process within which they have an encounter, I think, is much the same as what we're doing right now, as I would envision under this bill.
Thank you, sir. And one more question. I know we're brief on time. We got to be brief. So right now, my understanding is when law enforcement does detain someone or arrest someone, they don't necessarily ask right now what their immigration status is. They're taken to a facility, and that's where Border Patrol shows up, and that's where they question immigration status. If this bill goes through, will law enforcement have access to that, or who will be able to ask those questions about legal status?
Yeah, good question. I think yes. The answer is yes. It doesn't say that they're taken directly to a port of entry, but I think that they could take them and question someone maybe sometime in an air-conditioned office. Might be a better place to have a conversation than on the side of the road. So those things may happen. I anticipate that they will. So I don't think everything has to be done on the scene right at the location where they necessarily encounter someone.
Thank you, sir.
Okay.
Thank you, Representative, and we'll give you your right to close.
Thank you.
And we've given you about an hour, a little over an hour.
All right. Thank you.
So members, we've had the witnesses had registered at was it 1 o'clock? And then we have blocked the 4 hours, which we've announced. So we've had a request for resource witness to start. So clerk, start the clock. Steve McCraw. Steve, we have you registered Director, Texas DPS, neutral on HB4, is that correct?
Yes, sir.
All right. Members, do you have a question for the Director? They had a time, so I just want to make sure you were going. Then get the heck out of here before
Yes, sir.
something thinks something.
Thank you. Appreciate it.
Thank you, Steve. We appreciate you very much.
Well, before he leaves, sorry, I'll be quick. Because
Hold on.
Oh, yes, sir. My apologies.
So again, Steve McCraw, Director, Texas DPS, neutral HB4, correct?
Yes, sir. Correct.
Thank you, Mr. Chairman. I'm not sure if you heard the question that I had asked Representative Spiller about the family separation.
Yes, I did.
Can you tell us how DPS handles if a mother crosses the border with her child and the choice is to arrest rather than deport?
Our choice wouldn't be a choice. As part of policy, we would direct them to Border Patrol at that point, even if there was a state law for illegal entry. It's just how we operate. We don't want to separate the mother from the child. You're focused, the legislature and the governor's focused on the security threats. We're focused on that aspect. Mother and child is not the security threat. We would turn her over to the Border Patrol.
Okay, thank you.
Representative Lopez.
Thank you, sir. I just want to ask the same question I asked earlier. What determines when an officer does question anybody?
Well, probable cause. We don't just stop people. Probable cause, evidence. There's elements of the offense. And more often than not in the border, it's already been discussed. You actually see, individuals coming across, large groups that come across at that point in time. So it's, you have more than sufficient probable cause at that point in time to talk to them at the point. And of course, some of the other scenarios were discussed as well.
And then the second question was, will law enforcement have access to know legal status for someone? Because that way you don't apprehend anybody that does have legal status but doesn't have their documentation with them.
No, but we don't have typically, only ones that can determine legal status is going to be ICE or Border Patrol, the systems that they have in place. So we would have to do due diligence in terms of anybody we come in contact with, we address that.
Sure.
Representative Raymond.
I'll be brief. Thank you, Chairman. Thank you, Director. I just wanted to direct you to the author's comments, because he kept saying this bill would direct, this bill would, that law enforcement would, he expects, I don't remember how you said it, but basically the way he was saying it is like law enforcement, I'm going to focus on DPS. DPS gets someone who's here illegally. The author of the bill expects that law enforcement will take them. You heard the debate. I say it
Yes,
should
sir.
be shall. He says it's may. And so I guess I want to ask you, is it would it be, I guess, your directive, or how would that work? Would you, DPS troopers in Laredo, for example, if they got, this bill passes, becomes law as it is right now, as it's been drafted, they get someone, what are they going
The
to do?
least time processing in the jail, the better. So if you can get them to voluntarily cross back into.
Yes, but you heard him, and again, this is a very important point for me, and I think
Yeah.
it is for this whole legislation, is my good friend over here kept saying, you kept saying it, oh, they're gonna arrest them, they're gonna take them to the bridge and return them. No, it says they may, it doesn't say they shall. So, you know, and then he said, I think in his laying out and answering questions, well, it would be my expectation, he said, something like that, right? It'd be my expectation that law enforcement would take them back. So I'm trying to figure out with you, with DPS, would it be kind of like, it would be your expectations, or are you gonna tell my guys in Laredo, your guys in Laredo, DPS troopers that is, hey, by the way, the old Spiller expects us to take him to the bridge. And the governor expects us to take him to the bridge. Is that, how is that?
Well, first, I think that, again, the legislation would have to be passed, but how I envision it,
Yes.
if it's passed as it is very simple, is that the least that go to jail, the better. We've already overwhelmed the system with criminal trespasses.
Right.
So the more to the bridge that are willing to voluntarily go over, the better. Now, of course, due diligence.
Right.
We want to be able to do a name and fingerprint-based check on the front end
Right.
piece to ensure that we can focus. And it may be when we're doing that, we see someone has been previously deported and convicted of crime in Texas.
Right.
And whether it's sexual assault or something.
Right.
We want to charge that person.
Right.
Work with the district attorney and charge that person.
Absolutely.
So we can focus on the security threat. In the meantime, the numbers, you know, the overwhelming majority of the numbers would be going towards.
So it would be,
bridge.
so you would anticipate then that no matter who they got, so they get somebody, right? That at least the process of going, fingerprint checking, oh, we got a hit, right? This guy got convicted, they got away. Well, now we get to put him in, you know, sort of
Right.
another avenue. But it was just like, as I anticipate, most of them are not gonna, you know, there aren't gonna be any hits. Most of them are gonna be, no priors.
Right.
Now, all right, it's your hope, I guess, because you say the fewer that we're incarcerating, the better. So it's your hope?
Well, not our hope, is our directive, and we can get to control that, the way the
Well,
legislation reads. So.
I know, but the bill right now says may, Director. And I know
Yeah,
you
but-
can't comment on that.
Well, I realize that, but Chairman, there's great advantage of not taking a trooper off the road for several hours to process someone. It's far better to keep them on the road to detect and interdict transnational criminal activity. So it's a better deal, you know, if we're able to quickly turn people around.
Right.
And this is the points above my pay grade, certainly at the policymakers at your level, is I know you're trying to have a deterrent effect.
Right.
And how do you maximize
Yes.
that deterrent effect? And you've already spoken to the challenges, why not deport the long-term order, okay, request, or give them the option to return back to Mexico is, you know, obviously a solution, and it will keep more officers and patrol officers on the road as opposed to having them, taking them to the processing center, and from there TDCJ picks them up and so forth and so
So
on.
based on your experience, I guess you would agree that it is sort of in every way more effective or makes more sense, or however you want to characterize it, to take them to the bridge and say, go.
Absolutely, unless there's security risks.
There you go. Thank you.
Representative Turner.
Thank you, Mr. Chairman. So, Director, you heard my dialogue with Representative Spiller. You know, I'm trying to narrow down on you know, how exactly, you know, one of your officers or a local law enforcement officer a different agency, is going to be able to make a determination if someone has crossed the border unlawfully, to then trigger that sequence of events that you just went through with Mr. Raymond about returning them to a port of entry. And Mr. Spiller talked about officers will look at the totality of circumstances.
Yes, sir.
So what does that look like? You've got, a trooper or a local PD officer makes a stop or detains someone. How are they going about making this determination?
Well, it depends on the circumstances. As he said, totality of the circumstances. It could be, like we see, if an individual's in the back of a truck, tractor, semi-trailer, is certainly probable cause. Well, why are you hiding and secreted back here? During the conversations, they say, well, I just came across the bridge or between the ports of entry at Eagle Pass. So that's evidence at that point in time. So there's more along those lines.
It'd be a clear cut.
It'd have to be clear cut in that regard. I can't imagine somebody in North Texas. It doesn't mean it's not against the law. It clearly is if they crossed illegally, but I don't know how you prove it. Okay. At the end of the day, you need evidence. And I don't know how you determine it, because you don't go around asking people whether they're here legally or not, because I don't know how you would do that, because I don't know how you could detect someone just by their looks, that they're here illegally. I don't think you can do that. I don't think anybody can do that.
So it's not clear cut always.
Yes, clearly. And you would need, goes back to, you need evidence, and then you need the prosecutor. But I can tell you that, the idea that having a trooper in the Dallas area drive somebody down to, all the way down to Laredo International Bridge, not a good idea, or the Columbia Bridge, or just a waste of resources at that point in time, likely.
Yeah, I would agree, likely.
More than likely. But I don't know how they would get to there. They'd have to get to there, first of all, and to be able to prove that it's a violation, and then work. If it's a violation, they're going to prosecute. So that's the one-off, if you will.
So good. I think a good example. We've seen these horrific, human smuggling situations where people in the back of a semi or other obvious type smuggling type
Yes, sir.
situations. But for the most part, I mean, we know we have a lot of people who are undocumented in our state who aren't going to be in the back of a semi, right?
Yes, sir.
So when a law enforcement officer interacts with them, maybe they have a question, about their status, or they're not sure, but there's not really a way to ascertain absence.
I don't think so. I don't think it's been very difficult to do.
You don't think? I think the bill is silent on this, but would an officer ask, just say, what's your legal status? Are you a citizen?
I don't envision that unless you have probable cause, or a reason to ask that. I don't see that.
There's nothing in the bill that
Yeah.
says you have to do that, but there's also nothing that prohibits you from doing that. Is that right?
Yeah, but the violation is crossing illegally, into the state, not whether you're here, legally present, let's put it that way, lawfully present.
Sure.
That's, so someone could be a student, become an absconder outside of status. You just don't go around, that's not a violation under this. This is a violation only if you cross from Mexico into Texas illegally between the ports of entry, as I read it. I'm not an attorney, but that's how I saw it.
So, and as the bill author pointed out, though, because it is a misdemeanor, it's a 2-year statute of limitations, so it doesn't have to have happened today. It could have happened sometime in the last 2
Yes, sir.
years, and an officer could take an enforcement action under this bill if it's in the last 2 years.
Yes, sir. And I guess if you stop somebody and they said, look, I crossed, between the ports of entry in the Rio Grande Valley on this date at such and such, and I want to confess to that, that's evidence at that point in time. Certainly you've got reason to work with the prosecuting attorney at that point in time, but short of that, I don't know how you get there.
What if someone came over, through a port of entry on a visa, any type of visa, but overstayed their visa?
That's my point. They came here legally. They crossed legally at a port of entry. They flew into the country legally.
So
I
even
don't
if
see
they were
how
on
this would be
expired
applicable.
visa, this bill wouldn't give you
I
power?
don't see how it would. I defer to the author of the bill, but that's a federal domain, determine if someone's here legally or permanent or in lawful status, if you will.
Okay, thank you.
Okay, thank you.
Thank you, Joe.
Chuck DeVore. Why don't we pull somebody else up?
Sorry, he's here.
Okay, Chuck, we have you registered Chief National Initiatives Officer, Texas Public Policy Foundation for HB4. Is that correct?
Yes, Mr. Chairman.
Go right ahead.
Thank you. Chairman Hunter and members, I'm Chuck DeVore. I'm with the Texas Public Policy Foundation. And I'm speaking today on behalf of an initiative of ours called Secure and Sovereign Frontier. We're really focused on the threat to the Texas border and the ongoing challenges that we've seen with the government in Mexico and its penetration by the state cartel threat. I think these challenges have been thrown into stark relief today with the announcement from the Border Patrol that they just hit a new record for encounters on our border for September, 218,777. Since September is the end of the fiscal year, that totals up to about 2 million individual encounters this fiscal year, which of course brings us to House Bill 4. The bottom line up front is that we see House Bill 4 as a good bill, a constitutional bill, and a bill that ought to be enacted into law. There are two things that this legislation achieves that empowers Texas to deal with the border crisis. First of all, as you know, and as the testimony has shown here today so far, it creates an offense, first a misdemeanor and then a felony as events warrant, for illegal entry into the state across the international border. It also allows law enforcement to detain and transport illegal immigrants back to a lawful port of entry and to order their return across the international border. We see these measures as obvious and necessary due to ongoing...
That is your ending because it's only 2 minutes.
Yes.
We'll note that you're for HB4. We also have the printed testimony. Members, is there any questions? Thank you very much.
Thank
Joe.
you.
Justin Estep, E-S-T-E-P. Justin, we have you registered for Texas Catholic Conference of Bishops against HB4. Is that correct?
That is correct,
Go
Chair.
right ahead.
My name is Justin Estep. I am a practicing immigration attorney, excuse me, and also head of Immigration Legal Services and Refugee Services at Catholic Charities of Central Texas. We must emphasize that the church supports the right of a sovereign nation to control its borders. We want the federal government to enact effective and humane border management as part of a framework of comprehensive immigration reforms. All law enforcement agencies can and should cooperate with each other, but should not take over each other's responsibilities or jurisdictions. The obligation to control the international border lies with federal authorities. HB4, which creates a state criminal offense of entering Texas anywhere but a lawful point of entry, mimicking the offense in the federal code, is problematic for several reasons. First, it does not make any provision for those seeking asylum, not those who have received. Many migrants cross the border without lawful status, but then file for asylum or another form of relief as soon as possible through the federal system. The bill could significantly delay the federal process for asylum seekers, as the penalty for a Class B misdemeanor is up to 6 months in jail. The asylum process is already long and arduous, and to delay its initiation by detention is unjust. Moreover, the bill also empowers law enforcement to remove an individual in lieu of arrest, potentially denying them altogether the opportunity for a migrant to apply for asylum, which would be a grave injustice. Second, the cost to the state to implement this legislation could be enormous, considering the tens of thousands of migrants the state and local law enforcement encounter every year. The courts and detention facilities will be overwhelmed. There will also be the cost of litigation if the state is sued over this legislation. Third, the bill is unlikely to deter either migrants fleeing violence and poverty or the criminals engaged in human trafficking and human smuggling. Immigration enforcement should be exercised in a way that it is targeted, proportional, and humane. By targeted, we mean that enforcement resources should be focused so that those who are dangerous are more easily identified and apprehended. Proportional means that immigration laws should be not feature unnecessary
I can tell
penalties or
you're a
force.
lawyer, that's a red light.
Yep.
2 minutes up, we'll note you're against HB4. Representative Raymond has.
Thank you, Chairman. Be very brief. Do you believe that the federal government is doing a, let's just call it a good job of enforcing our immigration laws?
I believe that there needs to be comprehensive immigration reform, correct?
I don't want the long answer, yes or no. You think they're doing a good job?
I think they could do better.
So you don't think they're doing a good job?
Again,
Okay,
under the
so now
current
my second
circumstances,
question
they
is-
could be doing better,
My
yes.
second question is, then, do you believe, if, I have talked about this a lot, expanding the visa worker program would be a good step?
Absolutely.
Can you, since you all advocate, you oppose, so I assume you advocate, can you guys please start advocating for that? Can we please start getting you all that come up here and testify against everything, to start getting out there and being for something that there's probably going to be pretty good support across the board, Ds and Rs? And the business community is all for it.
We have advocated both through American Immigration Lawyers Association, through the
Keep
Texas
doing it
Catholic
louder.
Conference,
Keep doing it
or the
louder.
federal legislation, but the problem is there is no incentive, it appears, for there to be a compromise at the federal level to have humane laws in place while also making sure that we are maintaining our border security. It seems to be that neither side wants to disrupt the status quo because in some way, I think everyone benefits from the status quo
We already have a
currently.
visa program, a worker visa. We have it already, right? We already have it. H-1B, et cetera, right?
Well, that's,
So-
yeah,
so-
we have an
so-
H-1B program, which is for those with college degrees or higher, but not for manual labor
But the point is,
or,
we already have it. So this is.
not, no, I'd say that's an incorrect statement because we
Really?
don't have that for,
People can't come in here. I got 700 welders that came in from Mexico with visas to work in South Texas.
H-2A,
Okay.
H-2Bs.
So we have the program already, is my point. So let's just.
With artificial caps that does not take into
Exactly.
account the
That's right.
economy.
Artificial caps.
Yes.
We need to expand it.
Absolutely.
You can get agreement on that. Trust me, on both sides. Please start focusing on the part that we can get agreement on, and that's one that you can get agreement on. So, thank you. No further questions. You're now released. Go out and start championing that.
Thank you very much. Thank you very much. Did you have a question? Okay. You better go, Justin. Charles Maley. Charles, we have you registered for South Texans Property Rights Association and Self for HB4, is that correct?
That's correct, yes.
Go right
sir.
ahead.
Good afternoon, Chairman Hunter and members. My name is Charles Maley, and I am with South Texans Property Rights Association, a 501c3 based out of Falfurrias. We represent a diverse group of members scattered across the geographic area known as South Texas. Our members are routinely, daily impacted, as I have testified before, by the criminal elements or criminal aspects of illegal immigration. HB4 is going to be one more tool in the toolbox of our law enforcement community to help put a backstop or help slow down or stop illegal immigration, not because of the economic aspect of many of those migrants trying to come north, but the criminal element that's involved in that mass of migration. They need the tools to be able to put their hands on as many of those individuals and ask them questions about what their intent is to come into this country. And if that intent involves harming this state's citizens or this state's sovereignty, then we need to give them those tools.
Thank you. Any questions? Thank you.
Thank you.
Adam Haynes. Adam, we have you registered as Policy Director, Conference of Urban Counties Against HB4, is that correct?
Yes, sir, Mr.
Right
Chairman.
ahead.
Adam Haynes with the Conference of Urban Counties, and take just one little piece of my limited time. Thank you, Mr. Spiller. As everyone knows, he has been outstanding on this bill. His door has been open. He has worked with myself and our colleagues trying to address our concerns. And I publicly thank you, Mr. Spiller.
But you're against his bill.
But I'm against his bill because as Chairman Raymond said, it's close but not quite there. A couple of things. I've testified, the first time I've testified twice in front of this committee. I want to get back to county affairs and other committees, but similar to testimony I've given earlier in this week, the liability that this bill would transfer to counties and, more importantly, to property taxpayers is overwhelming. Not only for the incarceration and the holding, but also the adjudication, the probation, and all the things that go along with creating a new offense. And that new offense falls directly on counties, not the state. That's the Class A and the Class B misdemeanor. We would like to, and we've suggested language with Mr. Spiller. They're considering it, and we're working through some of that. But our main concern with this bill is in the second section when it talks about the indemnification and the liability and the removal of the torts. It is almost incalculable. It could be that much for defense, and if we were found guilty, if one of our officers or somebody goes out and acts inappropriately, the lawsuits that come and come to the county now, not the individual officer, we're going to have to be the ones that pay that liability. Thank you.
Thank you, Representative Raymond.
So, thank you, Chair. So, I'm going to ask you to tell us what, in your view or your association, what would get us there in terms of a bill? You know what I want, right?
Yes,
You
sir.
heard me.
Yes, sir.
I want return.
I understand. Yes, sir.
Would you all be for it if it was just return?
If one of the things that came up today that I actually like is put a limitation in terms of close to proximity to the border.
Right.
And the one thing that would help us with the bill is allow DPS, not our local law enforcement. This is a state action.
Yeah.
So let
Okay.
DPS be the one to.
Yeah, I figured you were going to say that as long as it involves, you're not going to be for it if it involves sheriff's deputies and all that.
I wouldn't go that far, but sheriff's deputies, constables can
Okay,
detain.
so 30 seconds. What would you support?
If a sheriff's deputy or constable detains an individual and has the probable cause to think that person crossed the border outside of a legal entry, then turn that person over to DPS and let DPS be the one to take them back to the border crossing.
And you'd be for that?
That would be,
Yeah, but-
if we can take off the liability and the tort and everything at the bottom of at the end of the bill, it's a non-starter for us.
Thank you.
Representative Guillen.
And so that doesn't let you, this bill doesn't let you do that?
This
Identify somebody you think may, or your sheriff's deputy identifies that they may have crossed the border between the ports of entry, and therefore they determine they're going to go give them off to DPS. Does this bill not allow that to happen?
It doesn't. The way I read the bill, and as you know, Mr. Chairman, I'm not an attorney, but the way I read the bill, it says the law enforcement officer that makes the stop, that makes the detention, is the one to return to the point of entry. I think you're right. It doesn't prohibit us from turning them over to DPS, but it does direct the law enforcement officer that makes the stop, that makes the determination.
So your interpretation is that the law enforcement and only the law enforcement, potentially only the law enforcement officer that makes the stop is the only one that can take them back to cross back.
The bill says the peace officer, so yes, sir.
All right.
Representative Grant.
Thank you, Chairman Hunter. Thank you for your testimony. Let me ask you this regarding the indemnification section on pages 4 and 5. Let's say, and this is a big concern that I think we've raised throughout, is that you have American citizens who don't have proof of their citizenship on them, and you have an officer that has to go through this complex analysis, detains them, arrests them, takes them wherever to the jail. The counties are going to be liable for the actions, for any potential violations, right? By a United States citizen bringing an action for a wrongful arrest, for example. Is that right?
That's the way we read the bill, yes, ma'am.
And in the bill, there's a section, page 5, lines 14 through 15, that say that this indemnification is not subject to the payment limits in, I guess, a different section of the Civil Practice and Remedies Code. How do you interpret that?
The way that our lawyers have looked at that is that the tort reform actions that have gone along and through this body and obviously the Senate, but signing the law over the last 20 years that have that this state uses for recruitment of businesses and promotes that we are a tort reform friendly state. It takes those caps off, and so
that's out the window. The counties now are going to be on the hook for defending any potential individuals who don't comply with the law and any lawsuits brought by American citizens who are wrongfully arrested under this statute. Is that right?
I think the phrase would be wrongful detention.
Wrongful detention.
We could be for I mean, if we took a citizen and said, "Are you here legally?" They said yes, and we detain that person as we're running, and you know, I mean, we're good and we try, but it takes us several hours, half a day, to run those papers, if you will, and that person, and then if they are here legally, either under DACA or one of the other affirmative defenses, sure, we could be sued for wrongful detention.
And this particular, and that's why I thought it was interesting that this particular statute includes language that y'all are on the hook. The counties are on the hook. That results in higher property taxes for property taxpayers, right?
The only way that 98% of the way that counties fund our budget is through property taxes. Yes, ma'am.
And the other just question that I have, and for this particular bill, is that assuming that an officer chooses that detention and arrest instead of the removal option, and they are housed in the county jails, that the exposure for counties statewide is in the billions of dollars. Is that right?
And then, I mean, if we get sued 100 times and are successful in our defense 99 of the time, one action under this with no caps could be astronomical. I mean, it is, the trial lawyers will love this bill if it happens that way. Yes, ma'am.
Thank you for your testimony.
Chairman Ginn.
Yeah, okay. I'm going to go back to what we were talking about just a little bit ago, because the way I read it, it says on page 2, line 17, 2E, a peace officer may, in lieu of arrest, remove a person detained for a violation of this section. A peace officer, not the peace officer.
Sure.
And so I fail to understand how that would mean only the peace officer that is the one that arrests or is at the point of holding them at that point. So I read it as any peace officer, because it says a peace officer. And then it says detained for a violation of this section by collecting any identifying information the person may have, 2, transporting the person to a port of entry, And 3, ordering the person returned to the foreign nation from which the person entered or attempted to enter. And so my read of this is that, particularly because of the may, and I know how my desk mate doesn't like the word may, but the way I read it is if a sheriff's deputy or a police officer of some city or county, any local law enforcement officer detains someone and they figure out that, or they have a hunch or whatever, they figure out that this might be somebody that could be charged in violation of this statute, and or someone that could be sent back to a port of entry and asked to be sent back, that they still have the option to determine if they want to do that or not. Do you think that this doesn't give them that option?
As I testified to, Mr. Chairman, what we would like is the clarity to say that it's DPS, but as you were reading that, your desk mate, the attorney, in this conversation gave you the thumbs up, and so yeah, I'm not an attorney, and as you read that, I agreed with you. I mean, you know, we might have the authority, but we would like the clarity that says that it's DPS that does it. If that's a deal breaker, you know, we can send that back to our lawyers to get clarity on that. But we would like the clarity to say that it's DPS and not the county officials.
All right, thanks a lot, Adam. Thanks, sir.
Thank you.
Ann Chandler. And we have you registered Executive Director, Texas Immigration Law Council, and self, neutral on HB4. Is that correct?
Now, let's make that against members
Hold
of
on.
record.
We have to correct. Okay, and so you give us permission on your registration to go from neutral to against.
Yes, based on what I've heard today, Your Honor.
All right, so we have Ann Chandler, Executive Director, Texas Immigration Law Council, and self, against HB5. Is that correct?
Correct.
Go right ahead.
Thank you. I'm here to pull upon about 20 years of experience of teaching immigration law and working on immigrants to highlight a couple very unfavorable, what I think, consequences of this bill. I'm sympathetic to some of the intent, but what I'm worried about is the actual application of what the bill says. It is very clear that this bill is across the state of Texas. And what I know from working with immigrants, especially when they're talking to law enforcement, is they're usually, in almost all circumstances, very, very honest. And I've worked with mostly survivors of violence, and there are most law enforcement officers that want to do the right things to secure the safety of their communities, but there are also some that just don't want immigrants present. And our laws of what it takes for probable cause is usually just an encroachment, just an ask. Just an ask is, hey, are you here? Are you lawful? Did you cross at a border? And most likely someone is going to be honest, and if they haven't, they will say yes. So real quickly, we're going to get to that probable cause of arrest. And that is what concerns me. I believe that everybody living in our community is best when they're able to trust local law enforcement to go to them to report child abuse, rape, domestic violence, human trafficking, fentanyl, and the list goes on. And what this does is it puts our local law enforcement in a place of enforcing our immigration laws that are broken, right? They are broken. But do we want to do that for our local law enforcement? I say we don't. It is complicated. Our local law enforcement does not have the records. It takes me sometimes months to figure out someone, whether they're lawful present. In fact, that's not defined in the act, and I don't even know what that means. What about someone who's applied for asylum? That's taken 4. I have clients who 13 years waiting for the process. So I'm worried it'll endanger our community. Thank you for your time.
And again, against HB.
Against.
Questions?
Yes, sir.
Representative Raymond.
Thank you,
Thank
Chairman. Is it your experience, since you mentioned victims of domestic violence, a lot of these cases, I assume, are going to be, a lot of these immigrants will be seeking asylum, right?
Sometimes, yes.
Sometimes?
I've worked with most survivors of domestic violence who have suffered that violence on behalf of an intimate partner, a spouse here in the United States, and have turned to law enforcement
Okay,
for
I'm
support.
sorry. I guess I'm focused on, when they're crossing, when they're coming over here. And what I was going to say, maybe you can't comment on this, but because I've certainly been aware of, them leaving other countries
Yes,
because it was so bad.
that
right?
happens too.
Those immigrants are going to go to the bridge. They're going to walk across the bridge. They're going to surrender and say, I want to claim asylum because they're going to kill me back home or whatever, right?
No, unfortunately, I've seen so many times they can't cross the board, so they are trying to figure out how to pass, and then they're looking to turn themselves in to law enforcement. So, but they are passing both at unauthorized ports of entry. Individuals who are afraid, who have suffered domestic violence, that is happening.
Thank you.
Mr. Chairman,
Representative Guillen.
I'm going to give you a scenario. And so let's say some town, PD officer stops somebody and they have reason to believe or some suspicion that they might be in violation of the statute. The statute would have passed at that point. And let's also assume that DPS or the state of Texas has not provided assistance with addressing these with paying for the cost that this statute would have put on them. Is there something in here that requires, or is something in law that requires them to enforce this statute, or do they have the authority to decide, you know what, we can't afford to enforce the statute? The state hasn't chosen to assist us in enforcing the statute, and so therefore we're not going to enforce it. In your interpretation of the law and of this bill, what are they forced to do, what are they not?
So I have a lot of experience of working with immigrant survivors of violence. I don't have professional experience with law enforcement of what they're forced to move forward and apply when it's a criminal procedure versus not forced. So I don't think I can give you a good answer.
I understand, thank you.
Yeah, Representative.
Thank you, Chairman. So you raised an issue that has come up over the last few years, especially after Trump was elected and started talking a lot about people being deported after previous legislation that this House has dealt with. And so my question is, and we've also worked closely with domestic violence shelters, and one of the big issues that came up is that a lot of women survivors of domestic violence or victims did not want to report to the police, period, because of their concerns. So even if law enforcement, chooses to arrest or not under this statute, the fact that this statute could potentially be in play, individuals will not even call the police. They will not want to call. Like, we've seen it. I've had town halls in our community with hundreds of families lining up in 2017, worried about what they need to do if they are stopped by the police. And it has taken law enforcement in our community years to try to build back those community police relationships so that people come forward and report crime. So I think that's what you're speaking to, is a fear that is going to be in the community, that already is, even when we're talking about legislation like this, and them even reporting to law enforcement. Law enforcement that I've talked to has told me that they want, that this is going to be damaging to police-community relationships. So is that what you're speaking to?
Yes, that's better said than I think I said it. I mean, honestly, let's just imagine that this is mostly enforced at the border. The laws existing will send a chilling effect across Texas.
And we've
right?
seen that
And
before.
I also believe that if the law is not limited, we will see enforcement of this in different regions and counties. There's nothing keeping a peace officer approaching a construction site, a cleaning crew, a landscaping crew, people who are doing hard work that our U.S. Native individuals do not want to do, and then being asked these questions to build probable cause for an arrest and a removal to the border. So,
and my last question for you is, because you're an immigration law expert, as you said, it's really complex to determine an immigration status, and it's taken months sometimes. And so for an officer to make an immigration determination, or like right at the beginning, is going to be very difficult, correct?
I'm not familiar with what type of communications on a scene happen between local law enforcement and our federal authorities, because the federal authorities are the ones that they too often take time to investigate, because sometimes information is with the Department of Justice, the Department of State, the Department of Homeland Security, so that can take time. But I think that kind of apprehension and the idea, okay, we know enough, let's move this person quickly to the border, could be very problematic and time consuming. It often takes us quite a bit of investigation and looking at paperwork. Just thinking about language differences. Most of the paperwork immigrants receive is in English. Many people speak Spanish, but we're working with arrivals that speak many different languages, indigenous languages, and across the world. So that kind of communication barriers, law enforcement officers doing the right thing, working in good faith, could also make some grave mistakes here.
Thank you for your testimony.
Thank you very much.
Thank you for your time.
Appreciate it. Melissa Shannon. Okay, Melissa, we have you registered for Bear County Commissioners Court, neutral on HB4, is that correct?
Yes, sir.
Go right ahead.
Yes, sir. Melissa Shannon, representing Bear County Commissioners Court, on the bill as stated, simply to state the potential fiscal impact to Bear County, which would be significant to the cost, the taxpayers of Bear County. As I mentioned on Monday with SB 11, we have approximately 80,000 undocumented immigrants in San Antonio and Bear County. And I stated the worst case scenario on Monday. Today I'm going to give you a not as bad a case, but if at the very minimum on this bill, if 10% of those undocumented immigrants are arrested and detained in our adult detention center, that's 8,000 misdemeanor cases. We'd need to add another new county court, 4 misdemeanor prosecutors, and a bailiff. At a minimum, and not including the legal costs that have been spoken about earlier, because we cannot ascertain those costs. We don't know what that could be, even with one trial. And the assumption is if one trial happens, then many more will happen. We're already, as mentioned on Monday, we're already unable to hire enough sheriff's deputies to man our detention center. Our sheriff's deputies are already maxed out. They are working mandatory overtime, 24 hours at a time. It's ungodly. And since this bill waives the state's tort reforms as mentioned, we cannot estimate the cost. So the potential cost to Bexar County taxpayers is in the millions of dollars, and it could add as much as a penny to our tax rate.
Representative Gant.
If the state or DPS or any other agency that you would expect would help pay for the increase in expenses that you incur due to the passage of this bill, if they chose or if they show a pattern of not assisting, do you not have, does the county, does Bexar County not have the authority to choose not to enforce this, therefore not incurring many of those costs?
I believe it's the officer's discretion whether or not to, if they see probable cause, and it's their discretion if they want to cite someone for this. Yes, sir.
Thank you.
Thank you very much.
Yes, sir. Thank you.
Hugh Lee. Hugh, we have you registered for yourself against HB4. Is that correct?
Yes.
Go right ahead.
All right, good afternoon, Chairman Hunter and committee members. So my name is Hugh Lee, and I'm the president of Austin Chinese American Network, a nonprofit organization dedicated to serving our community and fostering our cultural heritage. As an Asian immigrant of over 30 years in the U.S., I support legal immigration and sensible immigration policies that appropriately balance individual circumstances, humanitarian concerns, and national interests. This bill has good intention and many good provisions. But what concerns me most is Section 51.03D regarding a peace officer removing aliens without due process or due diligence. As you all know, many Asian immigrants don't speak English well, are considered bad drivers, and don't usually carry their ID papers when out and about. And additionally, there's a general cultural tendency to avoid interactions with a uniformed officer. My dad is a prime example of all above. He is a naturalized U.S. citizen living in Houston. He's 83 years old, feeble, bad English, bad hearing, and bad eyesight. And he freezes up when approached by a uniformed officer. So it is fair to say that without proper language, cultural, economic, and legal assistance, a questioned alien like my dad conceivably can be subjected to harassment and possibly a hastened and wrongful removal due to minor infractions. Further, this bill does not seem to spell out detailed processes, guidelines, trainings, and funding for the peace officers removing a suspected illegal alien. As such, I believe this bill needs significant improvement, and I urge you to vote against this bill as is. Thank you.
Hugh, thank you very much. Appreciate it.
Thank you.
Charles Reed. Charles, we have you registered as Assistant County Administrator, Dallas County Commissioners Court against HB4. Is that correct?
Yes, sir, that's correct.
Go right ahead.
Thank you. Here to testify against House Bill 4. I'm not going to repeat the testimony y'all heard from me on another bill. Sorry, I wasn't on another bill earlier this week. I do want, like my colleague, I do want to take the time to thank Representative Spiller, much like Chairman Guerin, for actually working with us on this, hearing our concerns, and actually taking them seriously. So I really do appreciate that. All of the custody costs I cited earlier this week they all apply here. Misdemeanors are served in county jails if they're brought to us. But I really want to focus on Section 2 of this bill. We are absolutely terrified of this section basically putting our property tax coffers up as open season for lawyers. You know, there's nothing stopping an officer from tacking this charge, this new offense, onto another offense, right? So you arrest somebody for burglary, you suspect that they might be here illegally, tack this on there. Everything that happens from that point forward is subject to unlimited damages once you waive all the limitations in Section 2. And so for that, we can't even calculate what that would do to us. I mean, it very well could bankrupt even an organization as large as Dallas County, depending on what the jury awards in the case. There are reasons that governmental immunities exist. There's reasons that there are caps on attorney's fees when you're suing a governmental entity, and it's so that taxpayers aren't put on the hook for potentially frivolous lawsuits. We have to defend every lawsuit that's filed against us. And if you open up our property tax coffers the way that they will be in Section 2, we expect just a litany of lawsuits to get filed against us, all of which we'll have to step up to defend. With that, I'm happy to answer any questions that anyone has.
Okay, thank you very much. Hugh, could you come back? I need to just verify again.
Yes.
Your registration says Hugh Lee Self.
Yes.
Against HB4, and that's how we should list it.
Yes.
That's all we needed. Thank you so much for confirming. Daniela Silva. Daniela, we have you registered for self against HB4, is that correct?
Correct.
Go right ahead.
Good afternoon. My name is Daniela Silva. I'm a resident of Austin, and I'm here against HB4, which will be a civil and human rights disaster. The bill could very well subject migrants and Texans across the entirety of the state to the threat of immediate detention, transport, and forced removal from the state. Removal would be based on an officer's interpretation of a complex immigration law to determine a person's immigration status. It has a strong potential to disrupt the established federal asylum system, which has existing procedures for identifying and adjusting immigration claims. These procedures are established for the well-being and protection of the most vulnerable people, including children who have endured significant traumas. The bill would exacerbate an indefinitely ongoing humanitarian crisis by using limited state resources for the mass arrest of migrants in the field and their detention in local jails or state prisons. It would also protect state officials and police from accountability by shielding them from damages or civil liability while they enforce politically motivated arrests and potentially wrongly remove people from Texas. This bill is immoral, unethical, and just poor policy. Instead of continuing with this anti-immigration crusade, the state could do the following. Petition the federal government to substantially increase asylum processing at U.S. ports of entry, support Border Texans' aid to migrants by providing needed goods, shelter, and dignified transport, build welcoming centers, and create a new system to help potential Texans adjust to life here. I ask that you not support HB4 and instead explore other options to ensure we can help people become the law-abiding citizens they so desperately want to become. Thank you.
Thank you very much, Danielle. Deborah Chin. Now, Deborah, we have you registered Civic Engagement Programs Director, OCA Greater Houston and Self, against HB4. Is that correct?
Yes, sir.
Go right ahead.
Thank you. Chairman, Vice Chairman, and honorable representatives, thank you for allowing me to speak today. My name is Debbie Chen, and I am the Programs Director for OCA Greater Houston. Since 1979, our mission has been to advance the social, political, and economic well-being of AAPIs in Houston. However, in solidarity with many of our brothers and sisters in our BIPOC community, we advocate for all Houstonians and Texans who can be impacted by harmful bills that would greatly decrease one's quality of life. I'm here to express our strong opposition to House Bill 4. HB4 criminalizes migration, including those who are trying to escape oppressive countries by seeking asylum outside of port entries, many of whom are women and children. This creates systemic barriers for many families that are seeking refuge in the United States. HB4 increases local and state law enforcement and to contractors to profile, arrest, and detain and remove anyone who they believe has crossed the border, quote unquote, illegally. And this would be based on an officer's interpretation of complex immigration laws to determine an individual's status. This gives local law enforcement full autonomy to act as ICE, as they would be allowed to essentially profile people. And not only would this take up wasted, limited public safety resources, taking away local control to utilize law enforcement to go after real criminals. This would also cause great fear amongst those who currently live in this country with legal permanent residency or are on a path to citizenship. There would be no accountability when and if people are wrongfully detained and or deported. People would not be able to even hold them financially responsible oftentimes, much less the cost to the counties. Somebody who is missing days from work will lose their job. People who are missing time from school will not be able to finish. Again, we hope that this committee votes against HB4.
And we'll note again, you're against
Thank you.
HB4. Thank you so much. Elisa Tamayo. Now, Elisa, we have you registered as Government Affairs Manager, El Paso County and Self, against HB4, is that correct?
Correct.
Go right ahead.
Thank you, Chairman Hunter, Vice Chair Hernandez, and committee members. Elisa Tamayo, again, a Governmental Affairs Manager for El Paso County against HB4 today. I want to echo everything that my colleagues in the urban counties just said and just mention a few of the costs for our county. Based on the state's estimation of 72,000 additional immigration arrests per year, and El Paso being a major player in these arrests, we are estimating a potential increase of 8,000 additional arrests per year just in El Paso. Considering an average of 30 days in jail per arrest, we would need an additional 240,000 jail beds per year. Our cost for jail beds being around 100 per day would mean a total of over 24 million per year in additional operational costs. El Paso County would also lose all federal revenue because we'll only have room to house the state inmates. So that's about 14.5 million per year on average. We will also need to increase capacity to at least 400 new jail beds, which according to the recent HOK studies, it will cost about 162 million to build. Even though the bill provides for the option for automatic removal, we as a county must prepare for the possibility of arrest that remains in the bill, including a felony for migrants that refuse to self-deport. So in summary, we will need the following funding to implement HB4. 162 million in infrastructure enhancements, 24 million per year in additional operational costs, and then approximately 18 million per year to address the concerns, all of the listed above. I think these costs are not even accurately estimating the added court fees, medical costs, bailiffs costs, increased adult provision cases, and the potential litigation costs resulting from the need to indemnify our employees for damages. For these reasons, we urge you to please reconsider the provisions on HB4 and commission an interim study instead that will help us further understand the actual cost of these policies before we burden the local taxpayer. Immigration policies should rest solely under federal government jurisdiction to avoid a double taxation approach to everyday Texans. Thank you so much.
Thank you very much. Thank you all. Appreciate it. Bethany Carson. Bethany Carson. Bethany Carson. Will show Bethany registered grassroots leadership and self against HB4 but did not testify. Jesus Perales. Jesus, we have you registered for Texas AFL-CIO against HB4. Is that correct?
Yes, sir.
Go right ahead.
Thank you, Mr. Chairman, members of the committee. My name is Jesus Perales. I'm here representing the Texas AFL-CIO, and we are in opposition to HB4. As the State Federation of Labor Unions, we represent 240,000 members all over the state, including various parts of the border region, with affiliates located in El Paso, Laredo, and the Rio Grande Valley. Many of our members are immigrants with mixed immigration status families, and they will undoubtedly be impacted by this bill. We see HB4 as an extreme anti-immigrant proposal that builds on Operation Lone Star, which will remind this committee has not achieved any tangible metrics and has cost taxpayers billions of dollars. Furthermore, empowering peace officers with the power of deportation will lead to human rights violations and to the erroneous deportation of U.S. citizens, lawful permanent residents, and other immigrants with lawful status. The labor movement strongly opposes these relentless attacks on our immigrant communities by attempting to pass legislation that is rooted in racism and the vilification of migrants seeking shelter in our state. We encourage members of this committee to acknowledge the dangers of this bill and vote to oppose. Thank you.
Thank you very much. Representative Yavi Criado.
Thank you, Chairman, and thank you for your testimony. I just wanted to touch, sorry, maybe my charger is, briefly on our labor shortage in Texas. So we have a huge labor shortage in lots of different industries, right? And how would this legislation from Texas AFL-CIO's view impact that?
Well, I mean, like I mentioned, we have a lot of union members with mixed immigration status families, right? And so the deportation of folks, automatic deportation by any peace officer in the state could just lead to further, labor shortages. We have a lot of folks who have, are lawful permanent residents who are DACA recipients, who are TPS holders. And as was mentioned earlier, some of these folks are going to be misidentified, and deported based on erroneous information. And so that would further hinder our ability to, meet those labor shortages.
Thank you.
Okay, thank you very much, Jesus. Barbara Hines. Barbara, we have you registered for self against HB4. Is that correct?
That's correct.
Go right ahead.
Good afternoon. My name is Barbara Hines. I'm a retired clinical professor of immigration law at the University of Texas. I practiced in the field of immigration law since 1975, and I'm testifying as an individual to oppose the passage of HB4. This bill is unconstitutional under the Supremacy Clause, particularly field preemption, not just conflict preemption. It also conflicts with the right to seek asylum. Texas cannot enforce immigration laws even if members of this committee do not agree with federal enforcement policies. Officers, and these are peace officers, not just DPS, have no authority to deport, whether you want to call it remove, take them to the border, under the threat of felony incarceration of 20 years under preemption statutes and under due process. Mexico is not going to accept these immigrants. They have no incentive to. Previous federal administrations have negotiated for months and years to try to get Mexico to house people on the other side of the border. And what's going to happen to migrants is they're going to be stuck really at the port of entry, going into ICE custody, which is what would have happened in the first place. But there's no way that non-citizens of Mexico are going to be returned to Mexico, even if this were constitutional or complied with due process. Determining alienage is very difficult, and certainly a police officer or a school monitor has no way of determining who is an alien as it's defined, who's a U.S. citizen and who's not. U.S. immigration law and international law allows migrants to file for asylum once they're in the United States, regardless of their manner of entry. This is very personal to me, as my parents and relatives fled Nazi Germany, and many of them crossed illegally across the border into Belgium and would not be here today. And for those reasons, I'm asking you to oppose the passage of this bill.
Thank you.
And I'm
note again against HB4.
Oppose the.
Correct.
Oppose, yes.
Representative Turner.
Thank you, Mr. Chairman. Thank you for your testimony. And you said, so I understand your qualifications, you are a retired professor
of immigration law. I directed the immigration clinic and founded the immigration clinic at the University of Texas.
Okay, so you have quite a bit of expertise in this
Yes, I do.
field of study. So you spoke how you believe this law is unconstitutional, in that to pass it would be encroaching on federal authority. I believe you may have been in the hearing room earlier when the bill author laid out the bill and said that he believed it was fundamentally different than the Arizona law that was found unconstitutional by the United States Supreme Court. Do you see such a difference or distinction between this law or this bill and the Arizona law that was ultimately found to be unconstitutional by the Supreme Court?
I do not. And I do not because basically that law attempted to copycat an alien registration law, and this bill attempts to copy 18 U.S.C. 1325, 8 U.S.C. 1325. And the other reason why I think it's unconstitutional is that the state has no authority to remove people, deport people, force them to leave the country. And so that is based on the concepts of both field preemption and conflict preemption, which are the two underpinnings of U.S. versus Arizona.
And you heard it in the discussion order with Mr. Spiller, his contention that this is not actually calling for a deportation, but simply a return to a port of entry. Therefore, that is a difference. But are you suggesting that basically it's a distinction without a difference?
I think it's a distinction without a difference. Basically, it says remove, and remove is the word that's used in the federal immigration law. So that's basically a deportation. You remove someone under federal law. And basically taking them to the bridge and saying, if you do not walk across the bridge, you will go to prison for 20 years. I think that's hard to say that that's not a removal or a deportation or whatever you want to call it. I heard someone say, well, people could decide not to do that. Well, I hardly think that that's a voluntary choice to leave. So I think this will be construed as deporting people, and you cannot deport people without due process. And certainly you can't have a local police officer making that determination. And that deprives asylum seekers of the right to file for asylum as well.
Thank you.
Vice Chair Hernandez.
Thank you. Do you also believe that this law and the removal provisions also violate our Texas state constitution?
Well, I am not an expert there. I think there's someone else here who's going to testify who is an authority on the state constitution.
I'll ask them. Thank you.
Thank you very much, Barbara.
Thank you.
Alice Yee. Alice, we have you registered for Asian Texans for Justice and Self against HB4. Is that correct?
Yes.
Go right ahead.
Yes, my name is Alice Yee, and representing Asian Texan for Justice, a nonprofit civic engagement organization, and myself to against HB4. Texas is a home for over 2 million Asian Americans, the third largest population in the nation. We have about 60% of Asians speaks other languages than English at home, and half of them with limited English. As Asian community have cultural and language barrier, and they cannot communicate at the spot if they were asked to approve their citizenship. They cannot explain if they are seeking asylum or renew their visa status, which means that even they are still in the process to determine their immigration status, or if they are Vietnamese or Burmese refugees and will become a legal immigrant soon, but they will still be deported. This bill will give police officers and peace officers and so much power, authority to remove people without due process. It would give the officers too much power and opens up a high risk of discrimination against Asians and people of color. They can profile us, whoever looks like Asians or whoever looks like Mexicans, they will be deported or being asked for proof of their citizenship. So please vote no to HB4. I know Mr. Speller may be in good intention, but there's a lot of worse bad consequences to this bill. And our Asian Americans do come from south border too. Last 6 months, we have 4,300 people coming seeking asylum from south border. Thank you.
Thank you very much, Alice. Thank you very much.
Thank you.
Roberto Lopez. Roberto, we have you registered Senior Advocacy Manager, Texas Civil Rights Project and Self against HB4. Is that correct?
That's right, sir.
Go right ahead.
Thank you. Chairman Hunter and members of the committee, my name is Roberto Lopez, and I'm an advocacy manager with the Texas Civil Rights Project. I'm here to express the Texas Civil Rights Project's strong opposition to House Bill 4. Representatives, with HB4, or the state's version of 1325 and 1326, you are playing with fire. HB4's illegal entry provision may one day be used to separate families at the state level. In the summer of 2018, the Trump administration weaponized improper entry under Title 8, 1325, cruelly ripping away babies from their mothers and fathers. This summer, DPS took dozens of fathers away from their children, clearly showing that the state is already open to these unconscionable tactics. It is dangerous to pass HB4 and recreate the same law that could be flipped like a switch to brutalize immigrant families. I worked that summer, that was my first summer of the Texas Civil Rights Project, and I never imagined that I would see families get separated by the U.S. government, and I could see that happening by the state. HB4 also encourages immigration officials, enforcement by officials who know little about complex immigration laws and the consequences of removal, with life or death situations hanging in the balance. We know that well. In 2009, Laura S., the daughter of our client, was living in Pharr, Texas, when she was pulled over by an officer for allegedly driving between lanes. When she couldn't produce documentation, the officer called CBP, even though she begged him not to send her back to Mexico, where her abusive ex would find her. 3 days later, she was removed to Reynosa, and soon after, her skeletal remains were found inside an incinerated vehicle. She was murdered by her ex. We've been litigating this case for years, and the family has not had any justice. The decision to remove someone's life is literally life or death, and passing HB4 will produce more tragedies like Laura's. We must try something other than criminalizing migrants year after year. Where are the bills appropriating billions in aid to shelters? Where are the bills for resolutions to the federal government to expand processing at the ports of entry? Where are those bills? Thank you.
Thank you very much. Appreciate it, Roberto. Naveed Zanjani. Naveed, we have you registered as Operations Manager, Houston AAPI Table and Self against HB4. Is that correct?
That's correct,
Go
Chairman.
right ahead.
Thank you, Chairman, Vice Chairman, and honorable committee members. The Houston AAPI table is a diverse table of 14 different nonprofit organizations that represent the AAPI table.
And you need to say your name.
Oh, Navi Zanjani. I'm the operations manager of the Houston AAPI table. This creates an issue for refugees, asylum seekers, and immigrant families, or people from AAPI descent and other backgrounds, because they can be mistakenly be taken in, caught up in a system which will take a while for them to get out based on the assessment of an officer. Is this equal under the law? Are we profiling people based on race and ethnicity? Are we doing it the same asks of individuals from Nordic, British, Dutch, or Canadian descent? We want individuals to not be afraid of police officers or peace officers and security contractors, and when issues do come up, right, in our neighborhoods and when injustice acts take place. We're putting a strain on our local budgets. We're taking away from real crime investigations in our neighborhood. Looks to me, this basically looks to me as a show me your paper law. It acts like a show me your paper law, and at the end of the day, it is a show me your paper law. Thank you.
Thank you. Appreciate it. Esther Reyes. Esther, we have you registered for Children's Defense Fund Texas and Self against HB4. Is that correct?
That's correct.
Go right ahead.
Good afternoon. Thank you, Chairman, Vice Chair, and representatives. My name is Esther Reyes, and I am Director of Immigration Policy and Advocacy with the Children's Defense Fund Texas. We are a nonprofit children's advocacy organization that believes that every child deserves a successful passage to adulthood with the help of caring families and communities. CDF Texas, or Children's Defense Fund Texas, strongly opposes HB4, which would subject migrants in Texas across the state to the threat of detention and forced removal by authorizing Texas peace officers, including those in schools and hospital districts, to detain, transport, and even remove individuals they suspect of entering the state unlawfully. For children and immigrant families, the threat, even the perceived threat, of immigration enforcement can have devastating effects, beginning before birth. Research finds that heightened immigration enforcement has troubling impact on babies, including decreased use of prenatal care for immigrant mothers and declines in birth weight. Fear of immigration-related consequences also cause immigrant families to forego vital nutrition support programs. In a qualitative study of 39 geographically diverse organizations in Texas, CDF Texas found that anti-immigrant policies cause many mixed-status families to fear enrolling even their citizen children in these programs. In addition, children's feelings of personal safety are linked to the perceived safety of those who care for them. Immigration, detention, and deportation are threats to personal safety and fuel fears of family separation. Let's take a moment to remember the irreparable harm caused by family separation under the Trump administration, which separated more than 5,000 children from their parents. Nothing in this bill would safeguard children from this devastating harm. This bill is plagued with legal and practical concerns, and I hope you will consider the disservice this bill does to immigrant children and families, primarily those who are Black and brown. I ask that you stand boldly against HB4 and step up for the well-being of children and families across Texas, regardless of their immigration status or the color of their skin. Thank you.
Thank you very much. Appreciate it. Sophia Avant-Meyer. Sophia, we have you registered for self against HB4. Is that correct?
That's correct.
Go right ahead.
Good afternoon. My name is Sophia Vantmier, and I'm a community organizer with Texas Rising in El Paso. I'm testifying against HB4. It's the responsibility of the state to protect and serve its civilians, not persecute community members and further oppress those in search of a better life. There is already a federal system in place to handle immigration cases, and this bill takes unnecessary steps in further traumatizing an already vulnerable population. Border communities are no strangers to racial profiling, harassment, and over-policing, and are the first to experience the effects of irresponsibly using taxpayer money to militarize the border even further when Texas ranks 53rd in healthcare, 28th in education, and 37th in quality of life. Further persecuting migrants using state funds is not emblematic of the wants or needs of border residents. In fact, it contradicts our values and neglects the fact that we are lacking resources and to deal with other issues. Using limited state resources to arbitrarily profile and arrest migrants would be cruel, dangerous, and a discriminatory exacerbation of a persisting humanitarian crisis. Moreover, allowing officers the authorization to detain, transport, and remove people that they suspect of entering the U.S. in a way deemed unlawful based on their interpretation of a loosely defined law, while indemnifying them from damages and shielding them from civil liability, is an audacious maneuver in a state that notoriously struggles with holding officers accountable. Peddling the notion that migrants are dangerous when this bill would endanger both immigrants and citizens is inhumane and hypocritical. Texans should not be perpetuating the dehumanization of asylum seekers. Please vote no on HB4. Thank you.
Thank you very much. Appreciate it. I'm breaking tradition and bringing up a lawyer. Luis Figueroa.
Thank you, Chairman. See, my eyes get so big. I'm so excited.
Luis, we've got you down as registered as Chief of Legislative Affairs. Every Texan against HB4, is that correct?
That is correct, Mr.
Go right
Chairman.
ahead.
Appreciate it. Again, Luis Figueroa in opposition to House Bill 4. I try to avoid hyperbole in these hearings, but I have to say on this one, in 20 years of doing this advocacy, I think this is one of the most impractical and blatant violations of federal law that we've seriously been considered in state affairs hearings in 20 years. And the reason for this is, one, enforcement is not a deterrent. We've already talked about this, spending $5.1 billion, lots of new crimes since 1996. It's not going to deter anybody, especially with the rhetoric that the border is open. But more importantly, a state-by-state approach doesn't work. Did you see in the news today that they're building a fence between El Paso and New Mexico because migrants will come from New Mexico and then come across the border into Texas? It doesn't work because we can't do this state by state, which is why it's preempted. HB4 requires an immigration determination. DPS needs to know whether the person is an alien, which means they're going to have to ask, which means it's not compatible with how DPS is doing their work right now. Lastly, removal is even more problematic and legally because of the asylum issues, because we don't have agreements with Mexico. We don't know what's going to happen if they're denied. We don't know about claims of citizenships, which does happen. Citizens have been deported in the past. We don't have training or translations. And lastly, there's already a federal process for this. There is already within the Immigration Nationality Act 287G, which provides for a process for local enforcement. This bill does not comply with any of that and is going to lead to a lot of not only legal violations and due process violations, but fundamental practical problems on the border as they try to process these people, and Mexico may not accept them. Where do they go from there? Are they charged to 20 years even though they were trying to comply? So many practical and legal issues here. So I very much encourage you to rethink this one and consider some of the expert testimony from our immigration attorneys. Thank you for your opportunity.
Thank you. Chairman Thompson.
I really hate to ask this question, but what happens if they are put out and Mexico don't accept them? What happens to the person then? Do they get arrested? Do they get put in jail, or just what happens? What is your thought?
The bill does not specify. My thought is they get turned over to ICE, and then we're basically where we started, which is, right now under current process under OLS, they get turned over to ICE if they're not arrested. So I'm not really sure what happens. I think that's one of the real problems with the bill is that it doesn't tell us what happens. I think at the very least, we should be putting in the bill a requirement that in order for someone to be deported, there must be there must be a provision about acceptance from Mexico. Otherwise, I think we're leaving DPS and the migrant out to dry in terms of violating this law.
I thought I heard some testimony earlier today that we had some MOUs with several of the border states, made with Mexico. Mexico.
Yeah, I did hear that, and I would just say that, one, I don't know the specifics of those agreements, but those agreements aren't indefinite, right? So what happens if we have it with one state and with not another state? My understanding is they're also not countrywide, so does it depend on what state that we're deporting them to? Is there variation between state to state? So there's a lot of just open questions there that I would have on that.
Thank you so much. Thank you, Mr. Chairman.
Representative Yavi Crowd.
Thank you, Chairman. Thank you for your testimony. You talked about the 287G, because can you speak more to that and what it is and how local law enforcement can opt into that?
Yeah, absolutely. So it's a provision in federal law under the Immigration Nationality Act. The reference is, that's the reference, 287G of the INA, and it provides for an explicit process for local enforcement. And you can go into those agreements, and it's there's training, there's requirements, there's details, there's an MOU. It's very explicit about what you can and cannot do. If you want to make sure that you do this in a legally way, in a way that's in compliance with US v. Arizona, you can do it through the 287G, and you can essentially avoid any doubt.
And those provisions of 287G are not not incorporated in this.
Nothing in the bill is references 287G.
Thank you.
All right, thanks, Luis. Good to see
you. You got it. Thank you, Chairman.
Thank you. Gloria Leal. See, she was gone the other day. Gloria, we have you registered League of United Latin American Studies and self against HB4, is that correct?
It's the League of United Latin American Citizens, LULAC.
Okay, so let's get we gotta correct it on the form.
Okay.
It's the League of United Latin America. Yes, LULAC. Yes. All right, so we've got the registration right. Gloria Leal, League of United Latin American Citizens and Self, LULAC, against HB4, correct?
Yes, sir.
All right, we'll get that fixed if we have your permission.
Okay.
Go right ahead.
Chairman, committee members, my name is Gloria Leal. I'm an attorney for LULAC. LULAC is the oldest and largest Hispanic advocacy organization in the state and in the nation. LULAC is nonpartisan. It's a not-for-profit. Our members are taxpayers, and we vote. I'm here testifying against this bill. I have appeared now twice in front of this committee after years of not. I will not be redundant, and I will not be completely legalese. However, our number one position is that this bill is unconstitutional in violation of Arizona v. United States. If you just look at the description or the preamble, says relating to prohibitions on the illegal entry into or illegal presence in the state by a person who's not an alien, the enforcement of these provisions, and authorizing the removal of persons. That is exactly what the case of Arizona, which is the law that says that the state cannot do. Any state law that creates any state offense dealing with immigration or enforcement is a direct violation and is preempted by the Supremacy Clause and by this case. I don't care what you call it, removal, detention, but if you're actually taking someone, detaining them, you're enforcing immigration law, which lies within the purview of the federal government. Second, it is clear from the testimony here today that this law would constitute a violation of so many civil rights of an individual, especially Hispanics. And, I don't care what y'all say. I'm from Weslaco. The only people that are going to get stopped and asked about their immigration status are Hispanics, possibly some Asian people, but they're not going to stop a white-looking guy. They're just not. So, third, we're going to monitor this case for future action. But Ms.
We have to stop you.
Okay, you need to ask me a question about family separation.
No. Now you're not going to get to. So we'll note that you're against HB4. Again, the rule in the committee is we don't have the witnesses ask questions, so we're not going to recognize that. Chairman Thompson.
Let me ask you, when was Arizona versus United States decided?
About 10 years ago.
We got a different thought on the U.S. Supreme Court. We have a different thought process on the U.S. Supreme Court.
Yes, ma'am.
Okay.
That's correct.
And there may be several states trying to send this issue up.
Exactly.
To get it reconsidered.
And this may be one of them.
This may be one of them. All right. Thank you.
You're welcome.
Thank you.
Thank you.
All right. Niloufar, Hafizi. How do you say the first?
Nilufar.
Okay, Nilufar. We have you registered as Niloufar, Hafizi, for, is it Engage or M-Gage?
It's M-Gage, E-M-G-A-G.
Okay, M-Gage action and self.
Yes.
Against HB4, is that correct?
Yes, Mr. Chairman.
Okay, thank you so much. Go ahead.
Thank you, Mr. Chairman, Madam Chair, Vice Chairwoman, honorable committee members. My name is Neil Farafizi, and I'm here on behalf of myself and Engage Action, which is a 501c4 that advocates for and supports just policies that strengthen our pluralistic democracy and human rights at home and abroad. We advocate primarily on behalf of Muslim Americans and AAPI Americans, and our programs and services include civic engagement and citizenship workshops for recent immigrants. I come from Houston, where about 500,000 Houstonians are estimated to be undocumented in a city of about 1.6 million immigrants, including about 70,000 refugees. This bill is extremely concerning for us and for the communities we care about, because we believe that it will encourage racial profiling, if not going beyond that, and also leading to unjust arrests and removals. First of all, looking at the track record of this overall legislative body, there is a history so far this year of targeting large counties, and Houston and Harris County in particular. So since HB4 applies to the entire state, we are concerned that it will end up leading to a situation where peace officers in Houston find reasons to target immigrant communities who already experience levels of fear that are not present in other communities. Many of these immigrant communities also don't speak English as a first language, of course, and any law enforcement interactions between them could lead to a situation where even someone who is lawfully present here cannot adequately communicate their status. And furthermore, on the point of whether or not someone's stop by a peace officer would be justified, a peace officer under this statute would be empowered to interpret probable cause, a reasonable basis for stopping someone by themselves. And that could include suspecting someone of being here illegally because they are part of a broader population that tends to come here not at ports of entry. So for this and various other reasons, I ask that you oppose HB4.
Thank you very much, and we'll note against HB4. Thank you.
Thank you.
Bob Leibel. Bob, we have you registered for Human Rights
Watch. Yep.
Hold on. Yeah, but to correct what? Okay. Bob, what we've got to do is get your permission to correct the registration to Human Rights Watch and Self against HB4.
That's right.
Instead of Human Rights, which is
how. Oh, okay. Sorry
Is that
about
okay?
That's okay. Yes.
Thank you. We
That'd
got
be
your
preferred.
permission.
Yes.
Go right ahead.
All right. Thank you, Chair. Thank you, members. My name is Bob Leibel. I am a consultant with Human Rights Watch, a nonprofit independent organization that investigates human rights violations in more than 90 countries around the world. We respectfully ask you to oppose HB4. Human Rights Watch has extensively documented the impact of Operation Lone Star, the program which has now cost Texas taxpayers nearly $10 billion in spent or allocated funds, has not succeeded in reducing migration or drug smuggling, but Operation Lone Star has led to dozens of deaths, injuries, and abusive detention conditions. Over the summer, some of these issues came to light when a whistleblower within DPS wrote a letter about how supervisors had ordered migrants back into the Rio Grande and denied them water. Later this summer in Eagle Pass, I personally witnessed National Guard troops denying water to migrants who were trapped beneath the concertina wire, including women in medical distress and at least 4 small children. I saw a toddler about my son's age nearly drown in the river, while Texas Highway Patrol and Florida game warden boats, who moments before had been racing up and down the river to create waves to deter the migrants, looked on from upriver in no position to help. The Office of Inspector General opened an investigation into these issues. As far as I know, there has been no report or a hearing in this committee or elsewhere about those investigations. HB4 would be Operation Lone Star on steroids. Instead of reining in law enforcement action or developing any kind of training plan, it would go much further than any legislation considered before in empowering law enforcement to detain, transport, and even remove people. HB4 creates a dangerous possibility of abuse. It empowers every peace officer across the state in all 2,700 plus law enforcement agencies, from DPS agents to your local middle school resource officer, to deport people suspected of having crossed into the country without authorization. We respectfully ask for you to not vote for HB4.
And we'll note you're against
Thank you.
HB4. Thank you, sir. David, Chincancan. David, we have you registered for Workers' Defense Action Fund and self against HB4, is that correct?
That's right, Chair.
And go ahead and state your name.
Good afternoon, Chair, Vice Chair, and committee members. My name is David Chincancan, and I am the Policy Director for Workers' Defense, and I'm here to testify against HB4. We strongly oppose HB4 because it is impractical, discriminatory, and extremely costly. It carries with it an enormous financial and moral cost to our state. Through the mass criminal prosecution and incarceration it proposes, it would strain already limited resources in our court systems, and it would burden Texans with the massive cost of unjustly putting large amounts of people in jails and prisons, and with the cost of forcing state and local police officers to take on the role of ICE or Border Patrol agents. Like Operation Lone Star, with its razor wires and inhumane practices, this is another proposal based on false narratives about the challenges Texans actually face. This oppressive and militarized vision for Texas that criminalizes migrants takes us away from actual needed solutions for Texans' families, like improving access to health care and building out long overdue infrastructure in our border communities. Beyond this tremendous financial and administrative cost, the bill carries an even larger ethical and moral cost. As Americans and Texans, we have a domestic and international legal obligation to protect migrants seeking asylum. These are folks who, facing unbearable economic and security threats, including persecution, violence, and at times even torture or threat of death, have no choice but to escape to protect themselves and their families. Instead of rising to meet this obligation in the face of this despair, we are piling on to existing suffering with further criminal prosecution. In doing so, we are making it even harder and more difficult for asylum seekers to eventually be recognized as such by federal authorities. It's clear that HB4 would create a dangerous law ripe for abuse, and you can be certain it will lead to human rights violations and separation of families. Please vote no on HB4.
Thank you very much,
Thank you.
David. Thank you. Andrew Hendrickson. Andrew, we have you registered for ACLU of Texas against HB4, is that correct?
That's correct.
Go right ahead.
I want to focus today a little on the...
State your name.
My name is Andrew Hendrickson.
There you go.
I want to focus today a little on the ways in which HB4 violates the state constitution, particularly Article 1 of the state constitution, the Texas Bill of Rights. HB4's removal provisions allow peace officers to impose a consequence for a violation of the penal code without the due process protections guaranteed by Sections 10 and 15 of Article 1, including the right to a public jury trial, the right to confront witnesses and obtain witnesses in favor, and being held to answer for a criminal offense without an indictment by a grand jury. It also violates Article 1, Section 20, the anti-banishment clause, which states that no person shall be transported out of the state for any offense committed within the same. In addition to that, Article 5, Section 21, the Court of Criminal Appeals and the Fifth Circuit repeatedly held that Article 5, Section 21 gives county attorneys and district attorneys the exclusive authority to decide whether or not to file criminal charges. Also, just a couple practical problems. There's a complete lack of guidance in the bill about when removal is appropriate as compared to filing criminal charges, meaning that the decisions on which path for law enforcement officers to take will almost always be arbitrary and capricious. Also, in addition to the situations we've heard about where folks came in from Mexico, for the re-entry provisions, it just entirely unclear what would happen if someone entered the country illegally from Asia or the Middle East and was expected to return to that country under those provisions of the bill, making it entirely infeasible for them to comply with the order or requiring Texas to buy a plane ticket back to those countries.
Thank you, Andrew. Thank you very much. Lindsay Gray. Now, Lindsay, we have you registered for VECINA and self against HB4. Is that correct?
That's correct.
Go right ahead.
Thank you. My name is Lindsay Gray, and I'm an immigration attorney. I also run a nonprofit where we train and mentor other attorneys to provide legal assistance to asylum seekers and the families and loved ones of unaccompanied children. I'm a former professor of immigration law for Washington University in St. Louis, and I'm also a former public defender for the state of Colorado. My colleagues have spoken about asylum processing, border policies, and legal issues regarding this bill. I want to focus on the family separation aspect because I believe my experience uniquely can speak to that. Practically speaking, this bill is going to result in family separation. When a parent is taken into criminal custody, the child cannot go with them, and so the child will be separated from the parent. If it's only one parent or if both parents go, the child will end up in the custody of the Office of Refugee Resettlement and ultimately in a facility or long-term foster care. If the parent is then removed, the families are separated, and we look at what someone referred to earlier about how the government has spent billions of dollars trying to reunite these families that were separated. If you say, well, family units, we'll just take them and we'll remove them. We'll let them go back to Mexico. A couple of issues with that. Then we see what happened with the Biden administration in 2021, where they exempted unaccompanied children to Title 42, which meant that they couldn't cross the border. And we saw this massive influx of unaccompanied children into the United States, and we got facilities at Fort Bliss, we got the convention center in San Antonio, and we had this massive crisis of unaccompanied children because the families have to make this horrible decision between keeping them in danger in Mexico or sending their children across the border alone, and many, many families chose the latter. I wish that Representative Raymond were still here because I was thinking about him earlier since he's from Laredo. In Nuevo Laredo, on the exact opposite side of the border,
That's what happens when you say Richard Raymond.
Yeah.
I guess so. Dang.
We will note that you're against HB4. And Representative Turner?
Thank you, Mr. Chairman. So on the family separation issue, I want to make sure I understand what you're saying. So you said a couple things, and you were going fast.
Yeah, I was.
Understandable. I didn't quite follow, yeah. But you talked about the impact on the foster care system. Can you just elaborate on that? Are you saying that you would have a parent or parents deported or removed,
or incarcerated in criminal custody,
or incarcerated, and then their children would remain in the United States? Am I understanding that correctly?
That's correct. I mean, what generally happens is if a parent is, and this is what happened during the zero tolerance policy, is that when the parents and child came across the border, the parent was charged with federal unlawful entry and put into federal criminal custody. A child can't go into adult federal criminal custody, so then the family is separated and the children end up in the custody of the Office of Refugee Resettlement. And so then they're ultimately placed in a facility or in foster care.
Okay. And so under this bill, if it became law, there's the option to arrest the person who's here unlawfully.
Correct.
And then there's also the option to return the person to a port of entry, to remove them.
Correct.
So in both cases, if someone's returned to a port of entry, would you, and I think the bill is silent on this, but if there's a minor with that person, does the minor go with them? Is that automatic? Is there some judgment there to be made?
Yeah, so
what happens?
I mean, historically, I've seen that family units are removed together. Okay. And so now there are some states, we were talking about different municipalities along the border in Mexico. There are some states in Mexico that will not accept families with children under a certain age. So, in certain cases, I would assume those families wouldn't be accepted, and then we'd probably end up, I think someone said earlier, back where we started. And then if the family were removed to Mexico, there's just mass. I was referring to Laredo earlier. There's a tree in Laredo that was known as the kidnapping tree because the federal government would, under Title 42, send people back all around the same time every day, and the cartels knew to come by and sweep up the families. And so these families with unaccompanied kids, they're forced to make, or with the legal definition of unaccompanied kids, they're forced to make this decision of, I can keep my child, I can return home to likely death. I can keep my children here in Mexico and risk kidnapping, violence, all of the things, or I can send my children across the border by themselves because we have no way to seek asylum in the United States. And that's what we saw in 2021.
So you would anticipate one of the potential outcomes here would be that parents would choose to send their children over or leave their children here if they have to go back in order to protect them from the cartels or violence back in their home country.
We saw it many times where parents just had to make the choice between Mexico or sending their kids across. And
in those situations, ultimately, the children would end up in the Texas foster care system.
they would end up in the custody of the Office of Refugee Resettlement, which is part of the Federal Department of Health and Human Services. So it's it's the ORR.
Okay, thank you.
Representative Aniavi-Grau.
Thank you, Chairman. On the family separation policies, so we read about a recent settlement as of a few days ago where the federal government is now going to be prohibited from this type of, family separation policies. Can you tell us, from your understanding, how that impacts this legislation, will be impacted by that, and is Texas going to be running afoul of federal prohibitions on family separation?
Yeah, so I'm aware of that settlement, and we are contemplating, working to again assist families in the reunification under that settlement. In terms of, I think this bill is, my colleagues have all said it, I think unconstitutional and runs afoul of the law for a host of reasons, that being one of them. I think not only the settlement is the state going to run afoul from the law, but also from the perspective of, is the state going to end up in the position that the federal government has been in now for some years, which is spending billions of taxpayer dollars trying to reunite families, and also, quite frankly, having massive public outcry, I think, across both sides of the aisle for what happened in 2018.
Thank you.
Vice Chairman Hernandez.
I want to go back to Representative Turner's example. And you were referencing incidents happening along the border, but this bill has a statewide impact. So let's say somewhere in North Texas, in Arlington, a mother is with her children. The mother does not have lawful presence, but the children are U.S. citizens. The mother's taken; those children are going to go into foster care in the area, right? They're not going to ORR.
I believe they would be going into state foster care at that point.
So anywhere in the state. So this could be North Texas, West Texas, East Texas. These children are going to be left in foster care when you take their parents.
Yeah, kids, when you take your parents away from children, they end up in foster care.
Right, because the law enforcement won't have any authority to take that U.S. citizen child, right? Just the parent.
Oh, no, it's an adult. So there's potential certification if a child is 17. It's potentially that they could be certified as an adult. But for children, no, it's an adult criminal statute, yeah.
Thank you.
Thank you very much.
Thank you.
Susan Hayes. I want you all to know this is the lawyer lineup for everybody. Susan, we've got you registered for yourself against HB4, correct?
Correct.
Go right ahead.
All right, thank you. My name is Susan Hayes. I'm an attorney, and my testimony is informed by my experience representing publicly traded companies all the way down to individuals, including migrants who were victimized while crossing the border. I also come at this because I am a landowner in a border county and spend a lot of time down on the border. Big picture, you're going at this the wrong way, in a way that is bad for business. We need the labor across all sectors, from ag to construction to services. The delays at the border by all the posturing are costing millions and millions of dollars for the companies that do business on the border and also disrupting our food supply. Rather than vilify and criminalize, what if we cooperated, processed migrants and refugees in an orderly fashion and let them work? What if we use some of the $1.5 billion this body is about to give to build a wall to help law enforcement do its job? Our forensic crime labs do not have the funding to test what they have. With fentanyl, with other adulterated drugs, with dangerous drugs, what if we use some of that money to treat the women and girls who were raped by coyotes coming across as the crime victims they are, process them, have sane nurses to take the rape kits, test that DNA and see if we can't catch the coyotes, the serial rapist. You catch a rapist, you catch a trafficker and a cartel member. Now, to the text of this bill, if one of my clients has a busload of workers with H-2A visas coming up to work from the border and get stopped, it's only an affirmative defense. That is disruptive to the business. It's disruptive to those people. They're going to get arrested. To the text, the indemnification provisions of this bill are bonkers. To say that ultra-various actions taken in good faith should be indemnified, that's an oxymoron. If you're operating outside of your power, you cannot be operating in good faith. And then the strangest provision that was not discussed in layout, indemnification for criminal actions. So you can beat, rape, or murder a migrant, and taxpayers are going to pick up the tab for that defense.
All right, we note that you're against HB4. Representative.
Thank you, Chairman. Thank you for your testimony. You said that you have clients that are publicly traded companies who have employees who have HB1,
H2A.
H2, yeah, sorry.
Right, sorry, it's confusing.
We have a labor shortage in the state, correct? So to the point where big companies are having to go outside of the state to bring in workers in agriculture.
Absolutely, and I wish not to invoke his name, but Representative Raymond were here because the system does need to be reformed. Companies can't get the workers to do the work they need. And with the H-2A visa program, it is complicated. Workers have to go back after 10, or kicked out of the program after 10 months. And also just knowing having spent a lot of time on the border and spent a lot of time in rural, I grew up in rural Texas, local law enforcement don't know much about immigration law. And it is so easy to see workers coming up in their own vehicles, or many of them carpool from Ojinaga up to my client's facility, and be pulled over, arrested, and under this law, and it's only an affirmative defense that they have legal status to be here and work.
And we saw what happened in Florida once immigrants were criminalized and they started leaving the state. There were fields that were not taken care of. There were lots of industries that were impacted by, lots of migrants who may or may not have had papers who left the state.
That, and again, I mentioned food because we grow less and less in the state. It's coming up from Mexico. The same publicly traded client has facilities in Mexico where they grow food. All this blockading, all of this posturing isn't addressing the key issues, and it's hurting business, it's hurting individuals. We've heard lots of testimony about separating families. And to say that state or local government should pick up the tab even when criminal offenses are committed is beyond the pale. That's not going to stop the migrants.
Thank you.
Thank you very much. Oh, Representative.
All right, thank you, Mr. Chairman. Susan, good to see you. You raised an issue that hasn't been brought up today about indemnification with respect to criminal acts. So just elaborate on that just for a second. And is there, in your experience as an attorney, is there anything similar or congruous to that in other parts of our statute, or is this a novel?
I think it's quite novel, and what I think is strange about the structure of the bill, and if y'all look I'm on the pages 4 and 5, chapter 117 with the indemnification, you'll see that subsection A at least puts some restraints on civil cases. If you act in bad faith with conscious indifference or recklessness, then you don't get the indemnification. But that restriction isn't in subsection C, which is about criminal acts. I don't understand the thinking there, and Representative Spiller, be happy to work with you on this and try to get to the bottom of it. But that also really struck me as strange and frightening because I've spent a lot of time on the border and followed some of the incidents that have happened there. There was an incident in Sierra Blanca about a year and a half ago where a guy who worked at a detention facility, and if that had been a state or local, he would be a contractor of local government, was literally hunting migrants in the desert and shot and killed a guy. Did it purposefully and was criminally charged.
I remember that, yeah.
Then Hudspeth County's taxpayers get to pay his defense. I don't understand what goal that accomplishes that's useful to the state.
Thanks for raising that. Thank you.
Thank you very much. Faye Colley. Faye, we're going to have to get a correction on your registration.
Yes, sir.
So we show Faye Colley, American Immigration Lawyers Association and self against HB4, correct?
That is correct.
We need to have your permission. The word American has an S where needs to be an A.
Oh, my
Is that
apologies.
all right?
That is all right.
Go right ahead.
I appreciate you. Thank you very much. My name is Faye Colley, and I practice exclusively in the area of immigration law. And I'm here to testify in my capacity as the advocacy coordinator for the Texas chapter of American Immigration Lawyers Association in opposition to HB4. Director McGraw this afternoon summed it up perfectly when he said, it is the federal domain to determine lawful status. So when state officials or peace officers begin to question, arrest, or remove people who've entered without inspection or try to determine if they have, they are in fact making a determination as to lawful status, which is prohibited under federal law. HB4 also is precluded under federal law for the following reasons. It prevents U.S. Customs and Border Patrol's ability to conduct credible, fair hearings and assess people for asylum claims or claims of protection under the Convention Against Torture. Jailing a person under this provision impedes a person's ability to be able to claim asylum, particularly within the 1 year if they're charged for or detained for over a year in Texas jails. Next, it perversely interferes with federal immigration authorities' ability to detain and expeditiously deport people who are crossing without inspection, especially if people are detained in county jails. Next, it creates an outright constitutional preemption through the creation of a state criminal penalty for what is an otherwise civil and administrative deportable offense under federal immigration law. Specifically under Arizona v. United States, the Supreme Court struck down Section 6 of Senate Bill 1070, which allows law enforcement officers to arrest an individual without a warrant if the officer had probable cause to believe the individual had committed a crime subject to deportation. As a practical matter, we're really concerned that HB4 will also fundamentally change the way law enforcement does their job in the state of Texas. State enforcement or law enforcement officials will need to ask people if they're stopped or detained about their manner of entry or what their immigration status is. And I think that will effectively has the risk of creating a de facto state immigration enforcement regime, which is also, something that's preempted by federal immigration law. Gosh, I have a few more minutes. Finally, I guess I wanted to talk about the indemnity clause. Oh.
So you didn't say Richard Raymond. Or just, thank you very much.
I appreciate
and we'll
you.
note that you're against HB4. Thank you so much. Thank you.
Thank you.
Daniela Hernandez. Daniela, we have you listed as State Legislative Coordinator, Workers Defense Action Fund against HB4, correct?
Yes, that's
Go right
correct.
ahead.
All right, good afternoon, Chair and members of the committee. My name is Daniela Hernandez. I'm the State Legislative Coordinator at Workers Defense, and I'm here to testify against House Bill 4. Workers Defense is a statewide member-based immigrant worker center that fights for better living and working conditions for immigrant workers in Texas. Workers Defense is strongly opposed to HB4 because it's unnecessary, puts our members, many of whom are immigrants and have mixed status families, and all Texans at risk of racial profiling, and it will have damaging effects on our communities. We're particularly worried about how this bill, as currently written, is statewide and will allow peace officers to racially profile Texans in the state inquire about their immigration status, and potentially result in their removal. It's disappointing that session after session, the legislature continues to criminalize and vilify our immigrant communities, the very same communities that have been building our state and are an essential part of the Texas miracle that this body loves to boast about. As evident by the testimony here from our community today, we're really tired of our communities being under the constant attack. I just want to reiterate that this bill puts Texans from across the state in danger, migrants that are seeking shelter and safety in our state as well. I'm not sure how many times the legislature has to pass bills that criminalize and hurt migrants before realizing that maybe that's just not the right approach at all. I urge you to vote no on HB4. Thank you.
Thank you very much. Appreciate it, Danielle. Members, that is the last witness affirmation. Even though we did have a cutoff and a time, I still need to say that, I guess I don't have to. We do need to just verify, is there anybody else wish to speak on, for, or against the bill who was registered? All right. If not, the chair recognizes Representative Spiller to succinctly, shortly close on his bill.
Thank you, Mr. Chairman. I'm going to keep it short, but I do want to clear.
Say, go ahead.
I do want to clear up a couple of issues that have been brought up briefly. One has to do with this indemnity provision in the bill and the caps and so forth. Let me say this: the cap. We're not trying to create a plaintiff's lawyer's gold mine here. The caps on the plaintiff's side under the law, under Chapter 101, 102, 108 of the Civil Practice and Remedies Code, are still in effect. And so the caps on recovery, on what someone can recover, are still the same. None of that has changed, and it has not waived any immunity whatsoever. The only way to get to these other concerns and these great numbers would be, frankly, if there was bad faith and the other things that were found, and if that's the case, it's exempt, and the counties and cities would not be obligated under the indemnification provisions anyway. So what I'm saying is, it's a red herring. That being said, I'm still willing to look at that. We'll continue to look at that. And we'll come up with some perfecting language. Number two, there's been some discussion about asylum. I want everyone to understand, aliens, as defined under federal law, have the right to apply for asylum. This bill does not prohibit that at all. In fact, if you look at the Arizona case and you look at 8 U.S.C. 1158, they don't say that you have to actually be in the United States in order to claim or continue to claim asylum. You can still start that process, do that process, continue that process. This bill does not prohibit that or affect that. This bill just says that you're not allowed to come here illegally. That's all it says. Lastly, for those that think that this bill is unfair, oppressive, discriminatory, I would, and maybe I didn't make it clear in my layout, but the law as to illegal entry under 1325 and for reentry under 1326 and for removal under 8 U.S.C. 1231 is the law now. The provisions that we're talking about, that is the current law. As a matter of fact, it's been the law for 71 years. So, and to say, and that law is, to a certain extent, is being enforced by our federal government, not to the extent that it should and not to the extent that it has been. From 2016, 17, 18, and 19 of these removals that we're talking about, those averaged 326,853 per year. The problem is that we're now at a rate of 72,177 for 2022. I don't know what the statistics are for 23. But the problem is that law is in place. That law is being affected by the federal government, but not near to the extent that it was. Therefore, we have the problem that we're with today. Lastly, I'll just briefly say, for those that say that this is unconstitutional and it flies in the face of Arizona versus U.S., I would encourage them to actually read that case again, because I respectfully disagree on each of the points made. And even the one point that the court found constitutional, we're not even doing that in this instance. So what I would say is, I believe the case stands for itself. Thank you for your time. It's been a long afternoon, and I respect your time and ask for favorable consideration.
Representative.
Thank you.
Thank you, Chairman. I just have one question.
Got it.
If we've heard some testimony about someone maybe returned to a port of entry and then Mexico denies them entry into Mexico. I think that's my charger. I don't know why it does that. There, sorry about that. If that happens, if they're denied entry into Mexico and then have no choice, I guess, but to come across back into the United States, are they going to be charged under the illegal reentry provision?
No, because they don't meet the requirements for reentry. I would assume that if someone is ordered to return and they're compliant in their attempt to return, but Mexico does not cooperate with that, these folks that are aliens that have been ordered to return have done exactly what they're supposed to do. So I would assume at that point that they would therefore be assimilated like anyone else that's coming through the port of entry, because the state at that point has elected not to prosecute them, instead has done the return. Those folks at that point have done all that they're supposed to do. So I don't know that they're penalized, but in any event, they have not refused to return. So therefore, the violation of that or the refusal to return under the second-degree felony would not apply. They could, I guess, technically could prosecute them for the illegal entry because that has occurred. But if you're opting in, if the state says, we're not going to prosecute you for that, instead we're going to return you, then I would think that they've made that election, and so therefore Border Patrol would assimilate them as they would with anyone else.
Okay. Well, I asked because it's not totally clearly just reading the bill, so that's why I asked, and maybe there should just be some clarification in there that if someone is denied entry into Mexico, that they can't, that's not a cause for charging them with the illegal reentry provision.
I know that that's not the case because it's not, to trigger for reentry, they would have to meet the requirements of that and would have to be returned, or not returned, but if they voluntarily return. If they are prohibited from doing that, therefore they do not meet the requirements for the criminal offense of illegal reentry.
Okay. Thank you.
Thank you, sir.
Thank you.
Oh, I have one question.
One question, I'm going to.
That'll be a good one.
One question, Una Mas.
Thank you, Chairman. Thank you for your closing. If an officer takes an individual, removes them to the port of entry and takes them there to the gate, you have to pay to cross, from my understanding, put $1 or something in. Who gives that immigrant the money to get back over to Mexico? Who's paying for that?
I can honestly say, number one, I didn't know there was a $1 fee, and number two, I certainly hadn't thought about it. I can look into that and I'll get you an answer for that.
Thank you, because then they'd be charged with that. So
Fair enough.
Okay,
No.
thank you.
Okay.
Thank you, Representative. Appreciate
Thank you.
it. Okay, now do I do this? All right, members, thank you, Representative Spiller. So we've finished with HB4. So we're going to go ahead and vote on HB4. So Representative Guerin moves that HB4 without amendments be reported favorably to the full House with a recommendation that it do pass, be printed. The clerk will call the roll.
Hunter?
Yes.
Hernandez? No. Thompson?
No.
Smithy? Raymond? Guerin?
Yes.
Guillen? Anchia? Turner?
No.
Metcalf? Dean?
Yep.
Slauson? Spiller?
There being 8 ayes and 3 nays, the motion prevails. That concludes our business for today. If there's no objection,